Okay, ladies and gentlemen, welcome to this 20th in the series of Coffee with the Bar. And before there are any cheeky comments or any wit in the meeting says anything, yes, punctuality is one of the attributes that are required to be a successful lawyer, and therefore we apologize for the slight delay. Anyway, in the first week of May 2020, when we were already 4 weeks or so into the lockdown, I had a chat about doing a session with him on a serious law topic. He was so busy writing and talking in various webinars by that time. And by the time he became reasonably free, our focus had shifted from law topics to slightly more informal, casual, entertaining, humorous, and informative sessions. And therefore, we who had been waiting for quite some time, we waited. And we were watching a few of his sessions as well. There was almost a professorial touch, a touch of a teacher to the serious law topics that he did, which were full of information, full of interpretations, and also were very relevant and informative to the legal fraternity. 5 days or maybe last week, there was this 5-minute video of him giving an answer to a question after one of his sessions at Madurai, at the High Court there, which caught the imagination of the general legal fraternity, and it became viral on all law groups. So again, we had a chat, and at that point of time, we decided that based on this thing that became viral, an interesting non-law topic, a fun and also interesting session could be curated, which would be to the benefit of the lawyers. This session was also to prove the point that he is capable of a bit of humor. So that is Anand Venkatesh, a sitting judge of the Madras High Court. Justice Anand Venkatesh, hi, and welcome to the session on Coffee with the Bar. And, let's start off on a slightly serious note. Though your courtrooms, the proceedings in your court are reasonably lively and humorous and interesting, a lot of people do not know this side of you. And it is precisely for this particular thing that we have this series, which have been curiously titled Coffee with the Bar. One of the reasons for Coffee with the Bar, as the name suggests, is to bridge the gap between the bar and the bench. This relationship between the bar and the bench, serious as it might be because it involves dispensation of justice, should also be fun and entertaining. Now, from probably April 2020 till around July 2020, Justice Anand Venkatesh has been known to the legal fraternity all over as a person who has, threadbare discussed and lectured on various topics. But many people, I'm not saying most people, many people do not know that he can also be lighthearted, fun, yet serious. So do you agree that this divide that is there between the bench and the bar, especially in the Madras High Court, should disappear? Well, what are your thoughts about that?
Yeah, good evening, Sriram. You started with a very interesting question now. I always believed, even as a lawyer, that to wear this hat of a judge or to wear this hat of an advocate at any given point of time, many times I saw it like a sort of some comedy scene. See, basically, we were not born a judge. No one was born a lawyer. Everybody was born as a human being. So I always believed that judge is a work which you perform in the court, and the lawyer is a profession which you pursue in an office room and in a court. And from there on, it should stop. The problem was that we start wearing that hat wherever we go. So as a result of which, what has happened is that there is a tendency, I'll have to really tell this, there is a tendency, at least in our bar, which I have noticed for quite a long time, about which many are very hesitant to speak, but I wanted to speak today. There is a tendency where there is an impression that a person who goes and meets a judge and talks with him does it with some agenda in his mind. Meaning, a person who goes and talks with the judge is perceived from outside like a person who knows the judge well. So therefore, whether he can be engaged for 2 cases before that judge, or just because a judge smiles at some person and sort of exchanges pleasantries with him, an impression is that, oh, the judge knows him. So that this is going on in our bar for quite some time. I have seen it for quite a long time. So therefore, what happens is that either people with such agendas meet the judges, or there is absolutely no scope for the judges to meet the advocates at all. Meaning the only meeting point will be at the court or during some proceedings or some functions which commonly both of them attend. Apart from that, I never saw any interactions that are happening, which is actually the opposite when you look at North India. In North India, I have seen judges and advocates move very closely. The next day when you see them in the court, each will be wearing their own hats and performing their own functions. So I thought that the coming generation must break this ice. This ice cannot be broken by persons who are already there in the profession. It requires a big rubber to rub it off. It is very difficult to do that, I know that. But the coming generation, I think, should not emulate this. Is my very strong view. This ice has to be broken, and with a caveat. The caveat is you should know where you have to stop, and more than that, where you should not be proceeding further. So I thought that through this webinar session, I wanted to convey one thing very clearly. That is, the interactions between the bar and bench should be more open without an agenda behind it. Agenda behind it is the one which is making it more and more difficult. The life is not about agenda. When a father talks with a daughter, a husband talks with the wife, a friend talks with the friend, there is no agenda behind it. They talk because they are that. The same way, let a judge talk with the advocate and advocate talk with the judge, because both are, after all, at the end of the day, human beings. So therefore, it's important that trait is imbibed by the juniors of the coming generation. I think it has to be developed in a big way.
Okay. Thank you. That was a rather candid, I won't say confession, a statement to make, especially taking into consideration the history and tradition of our bar. Okay. Now let's go to you as a law student. Basically, I do not know about other law colleges. I've been to a couple of law colleges to judge their moots, etc. But that was at subsequent points of time. In the early 90s, the Madras Law College was a place where some kind of an attitude is developed from what I saw. A. B, especially there were 5 years and 3-year courses. And especially for the 3-year courses, it was always a cradle for political ambitions. Now, you were a year senior to me there, and the first casual question to you is, other than coming and meeting Sendil and me near the cycle shed, did you have any other purpose in law college?
After I joined law, one thing which I realized was, more than being inside the classroom, most of the time it was always outside the classroom, even if you are interested in attending the classes. So therefore, what I understood was as a rule, time has to be spent more outside is what I saw. The one advantage I would say is that you will be meeting people who have come from across the districts in Tamil Nadu. Meaning you would not have had an exposure to meet such variety of people when you were in the school or in the college. Here is a person who will come from Thoothukudi, from Tirunelveli, from Salem, from Coimbatore, from Vellore. All types of people will be there, and you will find that these are guys who have completed their undergraduations also. So sort of people who knows a college life and all that. So when they come in, to really understand the very psyche of the crowd takes some time, because the way in which they look at things, the way in which they speak, the way in which they build up a relationship is not the way in which we do it in Chennai. So it took some time for me to really get into their style and the way, because most of them used to come from the this law college hostel, which we used to have at
Millers Road.
Millers Road. So, and many you will find people with sort of political moorings, I would say. So you will find such types of people whose majority of the people who are there, you will find are persons who are not really very much interested in practice and all that. They wanted to just get a law degree for whatever they wanted. You will even find people who are working in railways, who are working in some central government departments, suddenly coming and sitting next to you in the college, because at that point of time we never had these stringent regulations which prevented people who are already working. So it used to happen like that. So you saw a lot of varieties of people around you. So therefore, it took me some time to even understand as to what was really happening there. So the known faces, yes, I would go and talk with them and all that. But apart from that, it was more an observation than going and talking with them.
Okay. Did you have any, because especially in the 3-year course, many of our classmates, yours and mine, had political ambitions.
Yes.
They still do. Did you have any political ambitions at that point of time, at least?
I had nothing to do with politics right through. I had always observed politics from outside, and there was never an occasion where I got anywhere near it.
Okay. So you answered 50%.
Yes.
In a 3-year course in the early 90s in the Madras Law College, if you were not interested in politics, that means you were serious about practice. Was that it?
Yes, that's true. That's true.
Okay. Now, so you had made up your mind that you wanted to practice as opposed to taking a job as a law officer or manager or anything like that?
Yeah, I always said this, it was a choice and not a chance. It was a choice for me. So okay. The choice was to practice. So I was very clear that I will practice.
Okay, right. Now, you were a student then a junior, then you became a senior, and now you're a judge. Now you see interns, juniors, etc. So you've had a bit of an idea about how the law student right now is, because I'm sure you've had interns over a period of time.
Yes.
Do you see any distinction from how we were back then in the early 90s or the mid 90s and the students now? Do you see any kind of a difference?
So when we were doing the law course, we never had this concept of school of excellence and all that. That was something which started developing later. So what we had was 4 law colleges in Tamil Nadu, Coimbatore, Madurai, Chennai, etc. Four law colleges basically. So what has happened is after the great effort made by late Madhav Menon to bring in the school of excellence, the focus seems to have shifted to serious practicing, meaning people who join law want to really get into the profession as such in whatever manner they want to, either as a person practicing before court or as a solicitor or in a firm, whatever it is. So that trend has opened up So I find that there is a major difference between what we saw in law college at that point of time and what we are seeing now, in terms of exposure, in terms of focus also, So now, for instance, getting into a law college was not such a big thing at that point of time. And we have heard our seniors saying that we got into the law college because we did not get anything else. It was at that level. Whereas today, there is a big competition going on to get into, more particularly to get into the schools of excellence across the country. So the whole trend has completely changed. So what I see is that there is more seriousness in the juniors today than what we used to see at that point of time.
No doubt about that. No doubt about that. Now, considering that you did your law in the early 90s, it was slightly surprising that right from your first year, you were from the end of your first year, you were an intern, apprentice under Mr. B. Ramamurthy, is it not?
Yes.
43 law chambers.
Yes, correct.
Okay, right. So you were with Mr. Ramamurthy as an intern from 91, is it?
Yeah, so what happened was, I was roaming about with this Jolna bag and with this dadi.
Okay.
Around. So the people in my house started worrying that this fellow is either going to turn into a rowdy, or he is going to call himself an intellectual and waste his time. So that was the basic idea that was going on around my family circle. So one of my uncles knew B. Ramamurthy. So he had spoken with him, and he had casually said, yes, you can ask him to come to office. So that's how one day I got, I was informed by my uncle to go to a particular address. And so that's how I joined Mr. B. Ramamurthy. That's during the vacation of the first year. That's when I joined Mr. B. Ramamurthy.
Okay. Now, Usha, she finished a 5-year course in 91, and she also joined Mr. B. Ramamurthy, is it not?
Yeah, she joined in 93.
Yes. And is it a fact that you were instrumental in her joining Mr. B. Ramamurthy's office?
Yes, it is a fact. My father and Usha's father both were working in heavy vehicles factory, Avadi. So they both know each other for a long time. So during a casual discussion, probably Usha's father seems to have told my father that she is interested in practice. So at which point of time my father started referring to me going to Mr. B. Ramamurthy's office. So that's how one day they came home, and then she joined Mr. Ramamurthy's office.
Okay. So from around 1993, which is the time that you also enrolled,
yes,
till around 1997-98, both Usha and you were juniors under Mr. B. Ramamurthy.
Yes.
Okay. Now, other than that, did you have any other distractions as a junior?
Obviously, the destiny actually made Usha join me only because of that. So there was no other reason why Usha would have joined the office. That's the way in which destiny works, you know.
No, what a little bird told me was that you enticed her to join Mr. B. Ramamurthy's office.
No, actually I didn't entice. At that point of time, I never had any such intentions. So, but after she joined office, most of the time both of us will be fighting. So you should understand that where the fights happen more, it obviously ends up this way. So it ended up that way.
Okay, right. So as a junior, money was definitely a thing of some importance to all of us at that point of time. And it was in very, very heavy demand. Our seniors would never give us any money. Okay. And at that point of time, paying your juniors was not on the agenda at all. I'm not even saying it was low down. It was not on the agenda at all.
Yes.
So therefore, this is probably the first of the serious things that I'm asking you. Independent matters. I'm not asking for your experience with Mr. B. Ramamurthy, because let's not go into that. Normally nowadays, most offices do not encourage juniors to take up personal matters. You should understand, as you're aware, most offices pay their juniors a token amount. So the only way for a junior who's from outside Madras to probably sustain himself is to take up some personal briefs. If juniors are not allowed to take up independent matters, I mean, how does he sustain himself? What are your thoughts about that?
See, basically, I never had this issue because there was nobody to come and give me a case. Neither me nor Usha. Both of us never had a chance where somebody will come and give us a case and we have to get the permission of the senior to conduct the case. There was no such occasion. What we were doing is all those cases, all those briefs of Mr. Ramurthy only. But my opinion on this is this. My opinion on this is that I always find that if a person is not confident about himself, if a person hovers in mediocrity, the problem is that he always has this feeling of the feeling that somebody will surpass him, or somebody will knock off his cases, or somebody will take away clients, or somebody will be recognized more than what I am recognized. See, these are all various traits of a person who does not believe in himself. You can keep adding to this list. So as a result, what happens is that for a very long time, it used to be felt that when you are a junior in an office, you are not supposed to take up independent cases. Even if you get an independent case, you are supposed to hand it over to the senior. And the senior is the one who will deal with that issue. That used to be a practice, and it was followed to the T by many.
Faithfully.
Faithfully, it was followed. So that's the only way where you cannot have a misunderstanding with your senior. It was followed. I would say that it was followed because if it is not followed, then these consequences will be very different, very difficult to handle thereafter. So probably it was followed for any such reasons. But what I feel is that the seniors must ensure that the independent briefs which one or two a junior gets is allowed, and that does not in any way come in the way of the junior performing or contributing his might to the office in which he is working. Let me put it this way. The independent cases which a junior receives must not be to an extent where it stalls or it puts a brake or it hinders his role as a junior in an office. If it goes to that level, probably a senior will always say that either you be in the office or you take up independent practice. But that's very rare. That does not happen always. You get one or two somewhere. So therefore, I always felt that it is very important to allow the junior to do that independent practice. See, what is the reason as to why the seniors were insisting it? Because their seniors were doing it. And in turn, their seniors were again doing it. If a senior had thought that why should I continue with this? What is wrong with the person doing his own independent work, earning, and at the same time also contributing to the office? If that is opened up, the respect for the senior will be more, according to me. And this tradition of not allowing a junior to take up any briefs at all will be broken there. Because if a junior comes from an office like that, he will also follow the same footsteps of his senior. So what is happening is many of these things which are traditionally coming are blindly being followed without any rhyme or reason. Nobody questions as to why all these things. So my answer is this: independently, where a junior gets a brief once in a while, which does not hinder his work in the office, must be allowed.
Okay, right. Now coming to a bit of independent practice. Independent practice, when you take a decision, for example, when you took the decision in 97, 98 to become independent, I'm sure there must have been a lot of thought process behind it. Newly married, independence, no feeders, no background so to write home about. So therefore, we are looking at various investments when we talk about an independent office. The first investment is your time. You have to be there 24/7. It's not like your senior's office. Senior's office 24/7, that's a different thing. But it's a slightly different aspect when it is your own office. Time. The second thing is books, journals, etc. Those are all extremely expensive. Do you think, for example, straight question to you, do you think that in this digital era, books, journals, etc., are a necessary investment for any junior?
See, basically, it is like this. Let me talk something about the scenario that used to prevail at that point of time, and then I come here.
It's slightly different now.
Yeah. So the scenario that was prevalent, or that was there at that point of time, if you look at it, books, investing on books used to be a huge expenditure. That used to be a huge expenditure. When I say books, it's the commentaries, it's the journals, it's everything put together. So it used to be a very, very huge expenditure, which is a must for any advocate to set up his practice. Without those things, it's like trying to go to a war without weapons. So basically, this is very important at that point of time. So therefore, whether the advocate, that is one part of it, meaning that these are advocates who would have touched those books whenever they wanted to refer it and all that. But there is another set of advocates who would want to buy books just to sort of mislead their clients into thinking that they are in fact reading such books and all that. They would not have gone anywhere near that. But the clients, when they get into an office looking at those books, will get bamboozled. So basically, it's possible for them to really strike a good deal with the clients by showing their books. So those categories of advocates were also there. So books used to be a very, very important investment for an advocate. I would say even now it should be an important investment. It is true that we are in a digital era, and people are trying to digitalize everything. Even those books, they would want to have those books in their own pad or in a laptop. They would want the journals to be in their pad or laptop. They would prefer to have it in a digital format rather than having it in a physical format. So probably we are moving towards an era where going forward, probably an office may not have books at all. Everything will be available in the pad and the laptop, etc. But what becomes very, what rather confuses me many times is that I have attempted to sort of understand or get myself acclimatized with these of these journals and books and all that. But the problem is that it does not really stick to my brain. That's the only issue. I'm able to see a particular page at a particular point of time in a pad or in a laptop. In a book, what is that we do? In a book, what is that we do? In a book, we have the book as it is, and we start turning pages in a book. So it's like trying to travel through a path and trying to understand the entire path before you reach a destination. For instance, you want to reach my house. So I would say you first get down at Nagar bus stand. From there, you come straight up to Tiger Vardachari Road. From Tiger Vardachari Road, walk straight. In the left, you will get a police booth. After the police booth, you will get a red color building. After that, you will get to one departmental or small stores. Next to that, you will find a flat. So if this is the way in which we used to guide a person if somebody wants to come and reach our house. When you read a book, the same thing actually happens. When you read a book, the cover of the book, the pages which you turn before you actually reach to the destination in that book, the places where you mark it, the places where you fold the paper, all these things actually gets into the brain very fast. So while reading a book, I've always realized that it is like finding the way to my house. So every time when somebody asks you, you would have seen many seniors say, you please take that book in particular page. I would have written something in red ink. I would have underlined something there. I would have folded some paper. In fact, I remember having a book where I had killed a mosquito. That mosquito, that dead mosquito, you will find it in that particular page in the book. I used to remember that book also. So that is how we used to look. That is missing in case of a digital thing, because in a digitalized format, what you see at a given point of time is a page or a topic, which becomes difficult for me to really wire it in my brain. So coming back to your question, it also requires an investment. Digitalized, nobody gives it free of cost. It also requires an investment to be made. So the investment has to be made in some way. Either you buy it by way of books or buy it by way of a digitalized thing. But without books, there is no question of running an office today, an advocate's office.
Okay. Now coming to, you said it rightly. Even a digital office requires a hell of a lot of investment.
Yes.
At least the initial investment will have to be very high. Now the infrastructure, the staff, the juniors, and therefore expenses also increase once you try to set up independent shop. Okay. Along with this expenses increasing, temptations also increase.
True.
Okay. You have to necessarily make money for your office to run, leave alone what you take home.
True.
To pay your juniors, your clerk, your typist, etc., your subscriptions, you need to make that payment. So come what may, rain or shine, you will have to earn a minimum amount every month when you start independent practice. So therefore, the temptation due to distractions are very, very high. Now, my simple question is, let's not get into details. Have you ever encountered this kind of, some kind of temptation, etc.? Or has a red herring ever been dangled in front of you?
See, basically, getting into an independent practice involves something very important which has to be discussed in this forum, which juniors must also know. That is where you cut off your umbilical cord from your senior and get out. So you become independent there. So I do not know how it is happening now. At least at that point of time or the period before us, there used to be a lot of talk on poaching, on stealing clients. That used to be a big sort of controversy that used to happen for quite some time after a person actually comes out of an office. This is something which I'm sure all of us have heard about it. It used to be a corridor talk saying that this fellow is taking away the clients of this. So these things used to be a subject matter of discussion. So the first important thing was one must ensure after coming out of the office of a senior is that it's possible that a client who was a client to your senior approaches you. It has happened to me also. They would have seen your performance in the office and they will be independently coming and sitting with you to give a case to you. The most important thing is you should not take up those cases. It's a rule. You should never do that, because what happens is that it is unhealthy, and the client may be having 100 reasons for him to come to you. But I always thought that you have learned it from a person, you have laid your foundation with a person from whom you have come out. Thereafter, you should call it an independent practice only if you get an independent client. And it does not mean that you, after getting your foundation, you will steal everything and come out. And it's like, it is happening in many companies where a person is trained in software. He gets out of the company stealing all those softwares and he starts a company, a new company. So that way. So that attitude becomes very important. And that is where the basic traits actually works. You must be very clear that I will not take up cases or clients whom my senior has already dealt. Even if they come, you'll have to decently say either you go to my senior or you go to somebody else. I will not take up cases of that nature. This is very important because I personally feel that if you make your senior unhappy, if you make your senior sort of feel for what you did, where he may feel that you have backstabbed him, that is not good for your own development, because you never know how it will come back and hit you at a particular point of time, because everything everybody knows. It is discussed everywhere, everybody knows everything. You never know when it is going to stare at you. So the safest thing would be not to get into a situation like that. And so when you start a practice independently, the first thing you need to do is that you should not deal with the clients with who was earlier a client of your senior. That's number one. The second thing is, when you start an independent practice, I don't think you should think about clerk. You should think about juniors. You should not be thinking on all those terms. You should be first thinking about livelihood. First, you should survive. Survival is more important than show business. So what is important is that you have to manage the show. You have to ensure that you are able to sustain yourself in the beginning to run the show for a while. It's a step-by-step process. Of course, destiny plays its own role in all these things, but what I'm saying is that it's a step-by-step process. So to start with, there is no question of having a huge office. There is no question of aspiring for a car. There is no question of trying to have 4 juniors. All that, forget it. What is required is that you have to start sustaining yourself independently. So at this point of time, what is important is that you should never keep sitting in your office somewhere, in your residence somewhere. It's important that you come to court. Coming to court as a person who practices independently is very, very important, because you will never know who is going to interact with you in the court. You will never know which judge is going to appoint you as an advocate commissioner in a particular case. You will never know. In some cases where somebody will say that you please make this representation, I will go to that court and come. These are all small things which will be the actual starting point in your career. You may be sitting and reading something in the library, and you will go to a court. In that court, there will be some arguments which will be going on, which will touch upon a particular case law which you have read recently. So you may go near that person and say, sir, this is one case law which I read. That may be a starting point for it. I am only trying to find out the various ways in which it can happen. So when you start an independent practice, what is important is not to start thinking too much about the facilities, the juniors, the air conditions, all that is not at all required. What is required is to go to court. If you go to court, other things start automatically following through. So you will ask me, how is it you are saying this, sir? After independent practice, me and Usha used to go and sit in the second floor. During that point of time, the Advocate Association, the second floor used to be also a part of the main association. So we used to go and sit there. So it's free of cost. Nobody is going to ask you why you came here, pay this, nothing. You don't need to pay anybody. So that's your office. You are in the court, that's your office, and that's where you will have to start the whole thing. So we sat there. After we sat there, there was one gentleman called as V. Sundararajan. I have to tell about him at this point of time. I have to necessarily reveal his name at this point of time, because he was, according to me, sent by some god to give cases to us. This V. Sundararajan is a very interesting character who used to come to court at 9 o'clock in the morning. He used to run around places. He used to go to library. You can never see him sitting in a place and doing anything. And he is a person who believes in Josiam Jadagam. So what happened was that he used to actually get a lot of cases from Virudhunagar and all that. That used to be his native. So he was actually getting a lot of cases from there. And what we found was that he is not good in going and delivering it in court. He used to draft it, hand over the bundle along with some small fees to some junior whom he likes, and that junior will have to get it listed and argue before the court. Somehow he liked the face of Usha first. So he started calling Usha, and he will draft the whole thing. You don't need to do anything. He will draft everything. He will have stitched everything. He will just hand over the bundle, and he will hand over a new 500 rupee note or new 100 rupees five notes. That used to be like 5 crores. He used to hand it over in the morning. He started that way. We started actually that way. So slowly he started liking me also. And we used to have admissions in courts at least twice a week. So that's how it started there. From there on, slowly on our appearance in courts, and of course, since we come from the office of Mr. B. Ramamurthy, we used to be identified as juniors of B. Ramamurthy. So therefore, everybody knew that we are juniors of B. Ramamurthy. So judges sometimes you appoint us as advocate commissioners. That appointment of an advocate commissioner was a huge thing then. It was an income which was just given to you, and the income used to be decent also. So therefore, that is something which you used to receive. Then what happens is that you engage yourself this way, at least for half a day, till say 2 o'clock or 3 o'clock. Then you get back, then you sort of go back home, you start reading journals if you purchase journals, etc. So what is important at this point of time is to keep yourselves engaged in things like this than trying to really earn tons of money. If you do that at the initial point of time, you are right in saying that there will be carrots. There will be things which will be coming before you where people will be expecting you to do this and that. But fortunately for us, nothing like that happened because nobody knew us. Nobody knew us. And we are not that big people to come and approach where we will go and we'll be able to go and achieve things like that. So that never used to happen. Fortunately for us, it never happened. And that's why I was able to say it with a lot of confidence that as a junior, money is not the criteria. Working is the criteria. You have to have an attitude of working, and working, and nothing else.
Okay. Okay, fair enough. Fair enough. I was only asking for your personal experience and what you think that juniors should do. No problem. But the point still remains that in most cases, the decision to go independent is a tough and risky decision, especially for first-generation lawyers.
Yes.
You probably answered most of it in respect of the monetary angle.
Yes.
So therefore, if a junior has to take a decision to go independent, in your opinion, what should he keep in mind? Because that's very relevant now, because a lot of youngsters want to go independent at the earliest. What should they keep in mind, in your opinion?
A first-generation lawyer who joins this profession, if he has monetary support from somewhere, well and good. If he is being supported by his parents, fine. If he is supported by somebody, it's fine. But one thing he should be very clear, and that is that he is not going to be feeded with cases. He is not going to earn money for quite some time. I would say at least for 7 years from the time when he enrolled. That's how at least I have seen it. So if he is very clear about that, and if he is able to really sustain that particular period without getting attracted to anything, thereafter I think things fall into place. It's like one of my friends saying, how do you know that this month this client is going to come and give you a case? That's a question which is very difficult to answer. We are all living in hopes. Our whole of our life is about hoping things to happen. That's what the whole life is all about. So therefore, you have to hope that I will do whatever I am required to do. When I get a case, I will do my best. When I don't have a case, I will equip myself. I will go around and see how seniors are doing. I will go around and see how trials are happening. I'll go around and see how the system is working. These are things for which you may not have time at all once the cases starts coming in. So the way in which you have to look at it is, you will have financial constraints. You will face hardships. You will have a lot of problems. But I have always found that persons who come up with these types of problems are the ones who are very successful. I'm only reminded of what Kunti Devi told Krishna, that Krishna, please give me lots of problems in my life. Don't give me happiness at all. Only if you give me problems, I will be reminding you always. The problems are the ones which actually builds a character of a person. And a character building is very important for any advocate to be a successful advocate in this profession. So you should take that initial years of hardship, disappointments, etc., as a tool which is going to build up your character, and you should be prepared for it. You should be mentally prepared for it. There is no easy way.
Good thing that you mentioned this character building. Let's divide it into many parts. So we're talking about a young junior who wants to go independent. What do you think should be the purpose behind deciding to go independent? Because there are a lot of people who've been juniors for donkey's years, for 2 decades, 3 decades, etc. Should it be money? Should it be reputation? Or there are many juniors who think that freedom and having no restrictions is also a good reason to go independent. So what do you think, in probably 1 or 2 lines, what do you think is should be the purpose behind the decision to go independent?
The purpose behind going independent, see, one is the nature of that person itself. The person, the advocate, it all depends on the nature of a particular person. You will find people who would not want to be restricted in a particular sphere for a long time. So you will find those types of persons getting out very fast. There is the other next type of persons who after some time would want to, who by then will be sort of getting briefs, and at which point of time they may get this confidence that yes, this is the time I will have to move out and branch out and start independently practicing. Then the third type of advocates whom I have seen, some of the advocates who will attach themselves right through with a senior's office. So what I would say is that the best way to do it would be to see how you are being taken in the community even while you are working in a senior's office. While you are working in a senior's office, if you are able to get briefs, people are recognizing you. People want to give you briefs. At which point of time, at some time you find that yes, after this, if I continue in this office, probably there will be a clash, because I may have to go and attend to my case, and at the same time I have to go and attend the case of my senior also. That may become sort of ticklish there. So if you are able to, at one particular point of time, you are able to see that it will be possible, it is better that I move out and start handling my 2-3 cases which are coming to me, that's fine. That's the way, that's the time when you jettison out of a senior's office. Then I would say that people's nature, some people you cannot really restrict them to a particular place for more than, because they are clear that they are not going to get any big amounts there. It's all a token payment that is going to happen, and they will always find that it is totally disproportionate to the work which they are doing. See, at the end of the day, what will they see? They look at the world and see, person who is working so hard is paid so much, whereas I am working so hard and there is not even an improvement in my token amount which I am getting every month. So that will be a criteria for some people to move out and make an attempt to earn money. At the end of the day, everybody wants, so I'm not saying that everybody is going to go pro bono. Everybody wants to earn money. That's a very important criteria. But then I always feel that after a particular point of time, you will have to break that comfort zone and move away from it. The only way to leave, it's like this competition where you hold a pole, you run, you thereafter take off, thereafter you leave the pole and then fall into that side. To fall into an independent sphere, you will have to leave the pole here. So if you are to move out of it, you will have to cross that comfort zone. So when you are crossing that comfort zone, it's important that you cross it. Never ever stay in the same office forever. You will never have an independent name at all. People will always recognize you as a person coming from so-and-so office. It will stop with that. So your independent thoughts, the way in which you want to put certain things, all that you cannot do because you will always be within the boundary of a senior, office of a senior, etc. So I thought that it's better that at one point of time you recognize the fact that you have to go independent and you have to go. Thereafter, you should never stick on to a senior's office forever. It's only a place where you learn, and you don't stay in the school forever. You have to go out and start your own work.
Okay. Now, after becoming independent, maybe 15, 20 years of practice is when there will be probably an indication of whether a person is successful or not in the profession. I could be slightly wrong, but I think around 15 to 20 years at the bar is probably the right time to judge whether a person is made it successful at the bar. Now, this concept of being successful, which is probably pivotal to whatever we are discussing, it's different things for different people. For example, it could be money. Money could be the sole criteria of success. It could be knowledge. It could be reputation. It could be guidance as well. I will probably give you an example. Vedantam Srinivasan, according to me, was probably the last genius in the Madras High Court. My personal opinion, I could be wrong on that. Could his success, I'm sure you have interacted with him.
Yes.
Could his success be gauged purely on a monetary basis? I mean, what are we looking at when we say a person is successful?
My answer is quite straight and simple. Success is not monetary success. Because I have seen people who have monetarily succeeded, and many don't even know that they are advocates. So I have really seen a big crowd of persons who have practiced, who have actually lent their name, I would put it that way, who have really earned tons of money, and many will not even know that they are advocates. So money is not the guiding, or it's not the determining factor of success, is a straightforward answer which I would want to give. Okay, then what is success? Whom do you call as a successful lawyer is the next question. I would always say that a person is successful first, that he himself is satisfied with what he is doing. Because success from an outside world and what the particular person feels are two different things altogether. For instance, people from outside world think that people who are acting in movies, people who are stars, who are playing cricket, etc., are persons who are the happiest in the whole of this world. But when you move very close to them, you will find that they have tons of problems to be faced by them. So if you say whether those are successful persons, success is something which should not be measured from the outside world perspective. Success is something to be measured by that person who is performing the job. So if you are decent, if you are sort of happy, if you are satisfied with what you are doing, then I would say that that's the first sign of success. Then secondly, your contribution to the institution. That's very, very important to call somebody as successful. You should have contributed in terms of law. You should have contributed in terms of sharing your knowledge. You should have contributed in terms of march of law. You should have done something for this institute. You should have moved the institution an inch with your contribution. I would say that that should also fall within the list of things which I call as successful. Third is that, this is my personal opinion. Third is that you should conduct cases with your full might, with all your ability, even in a case where you have not received fees. Even if you have not received a single penny in a case, that should not come in the way of your performance before a court. That should never come. I will tell you one small example for this, and I'll again come back to the success. I was arguing a case before Justice K.P. Subramanian. That was a second appeal. Even now I remember that case. I was arguing a case. It was a contempt. That contempt was filed because there was some interim order that was passed in a second appeal. Part of it was not complied with, so there a contempt was filed. Of course, that case came through Sundararajan. That also I will tell you. So I argued. Then I argued, and he was smiling at me. And ultimately, he said that you have to go and execute that order, sir. There is no question of contempt. That was a case where there was zero fees. I received nothing out of that case. But I did my best to say that even in a case involving an order in a second appeal, it is possible to bring it within contempt. But it was not accepted. It was over. So I was sitting there. I was tying my bundle. Next case was a case which involved identity of a property of a place which somebody called as a corporation place. Somebody called that, said that corporation is trespassing into my property. Then Justice Subramanian lifts his head and sees me, and he says, "Why don't you be the advocate commissioner in this case?" So, if I had just left that case as it is, I always used to tell to people about this case, because if I had left it as it is, if I had decided that I didn't receive fees, I will not do my case, I will not do it effectively, then his attention would not have fallen on me at all. The reason why it fell on me was that he saw me doing a case well, in a case where I received zero, I received nothing. But ultimately, it gave me an income 10 times more than what would I have earned in that particular case. Probably I would have earned 1,000 rupees in that case. The fees that was fixed as an advocate commissioner was 10,000 rupees. So therefore, success again is the way in which you exhibit yourself in court, the way in which you portray yourself before a court of law. A person who does it well, one name which immediately pops in my mind is late Muthukumarasamy. Now I can talk about him because he is no more, but I always would want to look at this person. Persons have always seen him with R.K. sir, with R. Krishnamurthy sir for a very long time. And in the 90s, slowly he becomes the government leader. And he independently starts arguing before it. I'm not saying he did not do it, but his real independence, I used to see it during that 95 range, where he was a government leader who used to sit in that first court. From then on, if you see the way in which he has exhibited himself in a court of law, it went to an extent where whether he was appearing as an additional advocate general or as an advocate general or as a senior counsel for the petitioner, the court will go by what he says. The other side will be convinced with what he is saying in court. People will take whatever he says, they will know that this man will not cross that line of unreasonableness. So therefore, I will call that successful. That is very, very important. So therefore, if you are to ask me, what are the different traits which you call as successful? One, I should feel happy with what I am doing. I should not be unhappy with what I am doing. Number two, it is important that you are able to exhibit before a court in such a way that you are accepted as a lawyer who is dependent, whose words can be taken by the court per se, who is respected in the court. 3, a person who contributes to the profession by way of march of law, by way of sharing of knowledge, exhibiting knowledge, etc., that I would call successful. Yes, what happens is that, since you referred to sir, I want to tell that also. Now, what happens is that these are very peculiar characters. I would call them. I would not bring them within inverted commas the regular lawyers at all. These are people whose knowledge level is much higher. So what happens is that when they come before a court, they will not be able to take nonsense. They will think that I'm standing here and talking before, sorry to use those words, a moron who does not know about it, and I'm being asked to address him. So what happens is that in cases of people of that character, probably it is not safer to follow what they did in court. It's important to understand it, because it's possible that the courts may feel that instead of arguing, you are trying to teach the judge about a particular facet, or you are trying to be more like a professor in a court, or you are trying to show off in a court in front of other advocates and clients, etc. So I would say that that is something which is not a good advocacy, according to me. And that is not actually happening. That used to happen a lot at that particular point of time, where you had such giants who were at a completely different league altogether. When you start arguing something, and after 5 minutes the judge is going to ask you, for whom are you appearing? See, it's possible that a normal lawyer may not really get perturbed, but when you ask a lawyer like him such questions, he loses his patience and he says something in the court. So I would say that success in the sense of, you have to get them as an inspiration, take them as an inspiration for acquiring knowledge. But I would always prefer a Muthukumarasamy before a court than a Vedantam Srinivasa. That's my opinion about it.
You've just till now I was thinking that there was no controversy. You've made this controversial. But I mean, Vedantam was Vedantam. He was his own man.
That's right.
He was his own man.
That's right.
Anyway, would you? This is probably a very leading question. You can be politically incorrect if you want. Would you call yourself a successful lawyer?
I was happy.
But you can still answer that.
No, I would confidently say that I was a successful lawyer for three reasons. One, I was happy with what I was doing. I was so passionate about what I was doing. I was sort of loving what I was doing. So since it was giving me a lot of satisfaction, I have satisfied the first criteria about which I was speaking with you. Second was that I was also instrumental in contributing a small bit in the march of law. Also, if you look at the law journals, you will find that I would have been appointed as an amicus curiae in some important cases. I would have done my bit in the march of law. I had always tried to sort of share my knowledge, even as an advocate, to many others. I used to do free of cost to many juniors in court. 3 is that I was actually earning a good income. At least 5 years prior to becoming a judge, it was actually flowing. I was getting a lot of briefs, both in terms of clients coming and engaging me, and in terms of junior advocates coming and engaging me. So if I had continued that way, I am sure that I would have become a senior advocate with a good practice at a particular point of time. So in terms of success, if you ask me whether I was successful, I will confidently say that I was a successful.
Okay. Now, with all this probably 15, 20 years, or from 1993 to 2018, 25 years at the bar, you were elevated. You had avowedly no political affiliation. You were totally apolitical. You had no connections whatsoever with the center. You had no connection whatsoever with the state government. How?
There was this trend going on in our court where if a person has to be his name has to be recognized or his name has to go for a judge position, he should either be belonging to a political party, or he should be belonging to a particular caste, or he should be belonging to some association. All these things used to be a criteria for a person to sort of get a nod, a sort of recognition, even for an elevation. I think that Justice Kaul came and broke the whole thing. He completely broke down that whole concept of this judges selection, and he was the one who really opened it up, is what I would say. He was the one who really tried to identify persons for the purpose of recommending their names for elevation. So under normal circumstances, there was no way I would have become a judge of this court. I'll have to openly say this, because I had absolutely no affiliations for anything, and there was no way people are going to really, I would be the last, my name would be the last thing to come to the mind of a person, even for an elevation. But as things turned out, there was a lot of vacancies which had arisen, and there came this man at a very crucial juncture where the court was also undergoing a turmoil because of lots of things that were happening at that point of time. He came in, he cleaned up the institution. Obviously, he was looking for some meritorious persons to be recommended for elevation. So at that point of time, there were some senior advocates who had a lot of liking for me, because they have seen me performing from a distance. There were some sitting judges who liked me, who had seen me performing in courts. So therefore, I would not want to really tell all their names here, because it's a big list. There was a big list of persons who were all really liking me. So probably they thought that this person may suit for that post. And probably they were, some discussion was going on and they had recommended by name. I should tell you the truth. This at the time when Justice Vaidyanathan, Justice P.N. Prakash, Justice Velumani, etc., when their names went, in fact, they called my name also. At that point of time, I was 43. They thought with my white hair and that old look and all that, I was also old. But when they got my biodata, it was a shock of their life. Then they just said that there is no way you are going to be considered. So that was the time when I was considered. Then came this list that was prepared by Justice Kaul of 30 names and all that. People had spoken with him, and as you always know that he does not go by what you tell him. He goes by what he ultimately decides. So he saw my performance in courts. He sort of, I became a sort of blue-eyed boy for Justice Kaul. For some reason, he started liking me. It was, I always feel that he had that fatherly affection for me. I used to see it in his eyes. So he was the person who was instrumental in recommending my name for elevation. So let me put it this way. If not for Justice Kaul, if not for some of the senior advocates and sitting judges who had a liking purely because of my performance, there was no way my name would have got into the reckon for being elevated as a High Court judge. And I had one more distinct advantage where people did not know my community, because the way in which I speak, the way in which I project myself, nobody knew that I came from that community. But only when things started moving, people started realizing, oh, you also belong to this community. So that's where the disadvantage started coming. But I had this advantage of not being recognized. So that was also a big plus, because it was too late that people realized that I also belong to that. So therefore, I would say that if not for Kaul and a bunch of senior advocates and judges, there was no way my name would have gone to for reckoning for the elevation as a High Court.
Okay, I remember the few months before your elevation, when we always used to have a chat somewhere, there were, especially with S.R. Sundar and Lakshmi Narayan, you
Yes.
and me.
Yes.
We always threatened to do something once you were elevated inside your court. We've never been able to do that. That is to do one big.
That's
Okay.
right.
Right. I've just done it in public.
Yes.
Okay. Right. See, when you're a senior, you look for certain qualities in a junior, and a junior to perform well. You tell him that you go this, a similar spin of the same question has been asked to Justice P.T. Asha as well. So this is not a very original question. I asked it to Justice P.T. Asha. I'm just giving it a different spin here. When you send your junior to court as a senior, you wanted him to do a particular thing. You wanted him to fight in a particular manner. You wanted him to put across his point in a particular manner. And there are many occasions on which you, as a senior, you will tell your junior, do whatever you want, do not give any concession. Okay. Now that you become a judge, when a judge comes and argues or tries to defend the indefensible, one of the oft-repeated statements is, why can't you be fair? On the same point, you will have different opinion as a senior, different opinion as a judge. What is your take on that?
See, basically, even while I was practicing, when I used to find that there is no case, when I used to find that there is a sort of the chances of success is very remote, I used to tell it on the face of the client. That is something which I followed right through. I always had this habit of telling the client that this is your case, this is the maximum to which this case will go. If in spite of it, if you want to file the case, you file the case. This is what I used to start. That used to be the starting point of any case. So the clients with different ideas, I cannot say more than that. When I talk about different ideas, used to come and approach me. The straightforward answer which I used to give him was that I don't fall into that category. So therefore, you don't need to come. So what happened is, over a period of time, you will get the type of clients who will come either to fight their case because they believe that they have a case, and clients who will believe that you will do your best. So once that happens, you always rate your cases. You always rate cases, meaning you will find cases where you will think that you have to really fight for it. In such cases, the normal tendency is that you will not allow it to your juniors at all. You would want to go and do it because the client would have sort of looked at your eyes and you would have believed you to do that case. Therefore, in such cases, it is better that you don't give it to the junior at all. Either you ask your junior to take a passover or an adjournment and not allow the junior to do. That is one type of cases. The second types of cases are these borderline cases where interim orders play a major role. In these types of cases also, it is better that you don't leave it to the junior. It's better that you go and do it because your face value and the way in which you put the case before the court, the chances of getting an interim order is more, and that interim order for that particular point of time may be very important in that case. There are cases where you will find that you don't have a case at all. You know that. So in all those cases, before really making your junior go and do it, you should have a junior behind you. He should have seen you say the court that, my lord, this is the case. I don't think I have anything more to say in this case, but my only request to your lordships will be to say that I did not concede this case. I vehemently argue, and in spite of it, that's the only request you will make to the court. You will not tell the court that I conceded the point. So you should have allowed your junior to witness such things in court. It's important that the junior should have seen you perform in court, and the junior must understand what type of cases, how you put it in court. That is something which is very, very important, because the junior cannot go and do what you are doing in a court unless the junior understands how you do it in a court. That's very, very important. So, according to me, it's important that we first expose the juniors to final hearing cases. In final hearing cases, the papers are there, the pleadings are there, the evidence is there, everything is there. There is nothing special to go and tell the court about inventing something new in the court, except the point of law that is involved in the case. So in cases of that nature, where you find in a second appeal that there is not much of a substantial question of law involved, you have to call the junior and say, you tell these facts, and you tell that the junior knows what to say in the court, because the junior had already seen you reacting in a case of that nature before the court. So this is how you have to tell in the court. 2, when your junior is arguing, never stand behind the junior. When your junior is arguing, never be in the same court. I always used to follow this. When I hand it over to the junior, I will ensure that I am 100 meters away from that place. Because what happens is that you will start acting like Shivaji Ganeshan 100 meters away. The way in which your junior is arguing in the court, the junior will be put to a lot of sort of tension. You have to just allow your junior to do the case. And basically, you should believe your junior. Only if you believe your junior and the performance of a junior should you expose that junior in a court. Never expose a junior who has no court exposure at all, because it all depends on the judge who is sitting there. It all depends on the temperament of the judge. It all depends on what mood the judge is. And the junior may not even realize all these things. And the junior will be naturally acting in a court as if the junior is talking with some ex-survey. So when you expose a junior to a court, ensure that the junior has already seen you perform in a court. And the junior himself will pick it up, and it is possible for a junior to really perform in the way in which it is normally performed by an office. So to come back to your question, you should never tell a junior that these are negative points, don't tell it in the court. These are case laws which are against me, don't tell. All those things you will, when will you say all that? You will say all that when you are following such a practice. It all depends on what practice you are doing. What you do, you tell it to the junior. So you should not be one person and junior should not be another person. Junior is a representative of an office, and whatever junior is exposing before the court, he is actually exposing what that office is. So if you had set standards, the junior will also follow the same standard. So therefore, it's very easy as a judge to sit here and understand what a junior says. That many times in the past, I'm not talking about now, the judge will be able to see from which office the person is coming. That itself, 50% of it is over. The balance 50% of it is only that facts and law and all that. He will see from which office this person is coming. Every judge knew who are the juniors of a particular office. So if you come from A office or a B office junior, that itself has fulfilled 50%. Only the rest, the balance is that. So it all depends on these standards that have already been set by the senior. If it has been set, then there is no confusion at all. It will all fall in place. There is no need to really tell a junior as to what he should. Probably you may guide, but you may not say that don't tell this, don't reveal this, except I don't believe in that at least.
Okay, fair enough. Appreciation is a serious thing for any junior.
Yes.
Appreciation by the judge calling a junior by name,
yes,
is even more delightful. It is like icing on a cake, recognition in open court.
Correct.
So, number one, have you been appreciated in open court when you were a raw junior?
Yes.
You have.
Yes. I immediately tell you one instance which comes to my mind. Justice Lakshmanan. Justice Lakshmanan was sitting in a vacation court. I even remember the court hall number. Court hall number was 3. Court hall number 3. So he was sitting in a vacation court, and there was one case involving a land acquisition, where C. Prakasam had a case before me, and my case was after him. C. Prakasam's case he dismissed. And I had the case on very similar facts on the same issue. Next case I started arguing. Since he saw me as a junior, he just allowed me to argue. At one point of time, he understood that there was a very good point that is involved in that case. And what he did was something which I will not forget till today. What he did was, he recalled the order passed for C. Prakasam. He admitted that case also and granted an interim stay. He admitted my case also and he granted an interim stay. So therefore, there were many such instances which used to happen at that point of time.
That is not only appreciation, that is magnanimity to admit a mistake.
Mistake. So this is one thing. There are lots of, like Siva Subramaniam.
Okay.
There are lots. In fact, there was one tough judge called as Tu Meena Kumari. She had a very different temperament in the court. So this was the time when Sundararajan, I was telling you about one Mr. Sundararajan. He is no more now. It was his case, and he had attempted to argue this case through somebody, and he was thrashed in the open court. So I went the next time. I argued it before her, and she was very aggressive to start with. But as it progressed, it went to the level of where she told the other side that I am allowing this repetition. And she said that if it had been put in this way during the earlier hearing, by now I would have allowed it. Unfortunately, all these things were not brought to my notice. And that was a time when Tu Meena Kumari did not know me from Adam. There was no way she could have known me at all. So therefore, there were lots of instances where junior advocates were recognized. It all depends on how you performed in the court. If you perform well, obviously you will be recognized. But the other side also, the other side is we should develop this trait of appreciating people even for small things in what they do. It's very important that you will have to, if you see a small effort that is made, somebody gives us a citation, somebody opens up the book and says this provision, etc. You may be knowing that provision, you may be knowing that case law, you may be knowing more than what he's saying. But for that effort, if you are able to really tell that junior that excellent, fine, and you name the junior in the order, and you, apart from the case law which that junior gave, you add 2 more case laws from your side and put it and say that person had cited that before the court. I think all those things create a major impact on the junior. So instead of blaming juniors, it's important that as judges and as senior advocates, we should start appreciating even a small effort that is made by a junior in a court.
Fair enough. Good. Real confidence boosters for juniors, no doubt. Now, a lot of things for juniors to do, but more importantly, a lot of things that juniors or young lawyers should not do.
Yes.
According to you, what are the few things that should be avoided?
The first thing is body language. This is something which they can learn only when they observe seniors performing in courts. See, what happens is that they are exposed in a society where nobody really questions them or questions their body language when they talk with somebody. But when they come into an institution, this institution has already developed certain traits which has to be maintained in a court. So what happens is that the body language of the juniors requires a lot of what I would say focus. They should know how to present themselves in a court, basically, number one. Number two is that they should be honest to the court. If something is asked to them, and if they don't know about it, they should say, I don't know. Then, now at least with the present bunch of judges who are sitting now, you will find that they are very, very sort of encouraging to juniors, who want juniors to really fare well in court and all that. So it's important that the juniors don't take advantage of it and take things for granted. like coming to the court and straight away asking for a passover without a bundle in their hand, asking for an adjournment without saying why they need an adjournment. In the sense that they should know how to even ask for an adjournment. They should know how to even ask for a passover. So what's important for a junior, according to me, is that they should keep watching what is happening in the court, the way in which seniors are projecting themselves before the court, and they should try to build up those traits, those minimum traits of body language, the way in which they speak in court, and the amount of hard work they have put in that bundle, the thoroughness with which they have already read the bundle. If that is ensured, let me tell you, law will take care of itself. There is no problem at all. Law, I am not saying juniors should not be updating on law. What I am saying is that law will take care of itself if you are able to satisfy all these things. Confidence is good. Overconfidence is a problem. You have to be confident, but you should know where that line crosses and becomes overconfidence. You should know that there are certain body languages and there are certain expressions which they might be seeing the seniors do in court. They would maybe try to repeat it before a judge in a court, which will not be appreciated. After all, you must understand that the judge is a human being. And it's not as if all judges don't mind all these things. Each person in this world carries his own ego. The ego may be less, it may be more, it only varies in degrees. So what is important for a junior is to sort of put up a good image before the court. Everything controlled, the body language, the way in which they present, the way in which they have prepared a case, and honesty before a court. Honesty before a court is a major thing, because if you start with dishonesty in a court, two things happen. It becomes your habit, your character. Two, the judge gets a different impression about you, and thereafter, even if you come up with a good case, it will be very difficult to satisfy the judge because of the prejudice the judge is having on you.
We move on to this question of technology, internet, the digital space and all that. When you were a junior, even when you were an intern, I'm sure, all of us have grown up on textbooks, regular literature textbooks. Research, case laws, and in the rare cases where written submissions were insisted upon, all of it used to be well researched and then written.
Yes.
25 years ago or 30 years ago, research was not based on keying in keywords.
Correct.
You used to open the text,
correct,
look for a particular proposition, not a judgment. You look for a particular proposition in a text. And in the bargain, you will get judgments for 3 or 4 of your other cases.
correct,
But now, because of this entry of keywords, whether it is SCC Online or Manupatra, you normally, if you hand over the research part of it to an intern or a junior, you normally get 5 or 7 judgments, all on the same point. And there is no lateral thinking or lateral knowledge because of reading the text. What is your thought process on that? I'm sure you also use SCC Online and Manupatra, but what is your advice also?
Basically, I've said this so many times, but I have no hesitation to repeat also. I think basically reading journals as a practice, as a repetitive practice is very important. You read it either physically or you read it either digitally. But what is important is you have to keep reading it very, very regularly. It should become a habit for you. So, mode of reading, where from you read from the pad, you read from the book, I have no problems. But you have to read it, you have to note down the march of law, and you have to know where the law actually stands. That's the correct way of understanding a law, and that's the correct way of understanding the law of precedence. That used to be more easier during our times and times before that, because what we were exposed was only books. There was no question of any digitalized form of it. So naturally we may have to open a book. So when it comes to journals, we'll have to read journals. We keep noting it down. When it comes to understanding a proposition of law, you have to necessarily take a mullah. You'll have to necessarily take a textbook, and you have to keep flipping those pages. As I was telling you, flipping of pages is a very, very advantageous thing. That's what I said, like finding the route to my house. Flipping of pages had a lot of advantages which is not available in a digital mode. So what is happening is that there is this tendency of trying to find out a body for a shirt instead of trying to find a shirt for a body. The shirt has to adjust itself to the body. Body cannot adjust itself to a shirt. Now, because of easy availability of these case laws, instead of getting the facts of a case properly, you are trying to put the facts in accordance with the case laws which you are already having. This is a trend which I am seeing a lot these days. And people think that if you throw 10 case laws into court, you have a case. That's absolutely a wrong way of understanding law in my view. See, basically when we used to go through books, what happens is that we incidentally trench upon areas which we did never planned when we went into that book, but which also will catch our attention and which used to be suited for some other case which we are already dealing with. Or it used to suit some other case about which some colleague of us spoke up with us some time back, where we can tell him that when I was going through this, I found this. This is something which you will miss if you start going straight into case laws by just putting those keywords, etc. And the second thing is, I always find that law of precedence is meant for maintaining consistency. Law of precedence is not meant for clogging or creating a cloud over your imagination or putting a cloud over your innovation or march of law. If that happens, we are in a great danger. The danger is that insofar as facts of a case is concerned, there is a law behind those facts, and the case has to be decided in accordance with the law that is applicable to a particular case. You will go into the precedence only if it is really necessary in order to understand the nuances that is available in the law, the nuances that is there in the law. If you don't do that, if you just take a precedent and start throwing it, I find the people arguing before the court straight away saying, "My lord, your lordship knows 2019 2 SEC," without even going into the facts. Straight away it starts from a case law. It used to start from facts and go into case law. Now it is the ulta. It starts from the case law and it goes into the facts of the case. That is the effect of keying in these words. So therefore, this is an important question. According to me, this is a practice that should be completely avoided. You should follow the traditional practice that used to be followed. And if you have already read a case law, if you already know a case law, you have read it, then there is no problem in keying in and trying to get that case law. But you should not be doing it as a first instance where you even without understanding what that case law is, keying in and throwing away 7 judgments before a court. That is a practice that should be avoided.
Okay, right. Very slightly different point that has come about over the last maybe 10 years or so. The law and the media. Sensationalism caused by the media. Lot of lawyers giving interviews along with their clients. In some cases, the lawyers remaining behind and the clients talking in front. And, it effectively trialed by the media, because not only is the judiciary having a particular perception of a of a proceeding, lawyers also have a particular perception of the proceedings. Now, my question is not what can be done to avoid that. See, a lot of these young lawyers keep seeing this, and many of them have in fact come to me and asked, is that the proper way? Because many of them think that appearing on screen is the surefire way to success. When I filed a writ petition on behalf of X, challenging the discretionary quota by the housing board, in which unfortunately some retired high court judges were beneficiaries, because of that only controversial thing, the media wanted to interview me. I said, please, normally in a court pass matter, you can kindly contact my client. So that was my thought process then. But having seen this over the last 10 years, what would you tell these juniors who now look at some interview about a pending case on a day-to-day basis? Well, what would you tell them?
I think this is a latest trend that has developed. This is very prevalent in Western countries,
Yes.
Where all that is possible, even in an ongoing trial. I have seen in the O.J. Simpson's case, I have seen both sides going before the media and giving their views, even when the case was proceeding. So therefore, this is a trend that has now set in India. See, according to me, what is very important is that what the media knows is not the complete facts of a case. What the media knows is only an issue that is involved in a particular case, and they go about with their imagination and their views about that particular case. So what is important to understand is that you should never fall for all these things, because today that may be a sensational thing, but 2 days thereafter people will all forget about it and there will be the next sensation that will be coming in. So therefore, if everything is based on sensation, it's better that you don't fall into those sensational things. You keep doing your work. You don't keep feeding to media. If you start feeding to media, then you may have to take cases like that, and instead of satisfying your client, you may be satisfying your own ego. You are not paid fees for satisfying your ego. You are paid fees because you have to fulfill the needs of your client.
Okay, right. The next thing is, which is prevalent of late, is the law and the common man. Previously, we had clients coming to us, telling us, these are the facts. Sir, I want you to do something. Nowadays, you have clients saying, these are the facts. I have done a Google search. I have done Manupatra search. I have done India Kanun search. These are the judgments. The Bombay High Court says this, the Calcutta High Court says this, the Delhi High Court says this. This comes especially in the case of matrimonial cases, yes, in which the Bombay view is totally different. Yes. They're very, very interactive.
Yes.
So now people come with half-baked knowledge, half-baked information, and expect you to go in a particular manner.
Yes.
Would you suggest that juniors strongly oppose and do not fall into this line of thinking? Or would you have a different opinion?
Sometimes what will happen is that I have seen this happen to doctors also. So before they go and meet a doctor with a particular problem, they Google everything. And instead of going and telling their problem, they go and start testing the doctors. So what is happening is that the clients must never be allowed to test your knowledge. If they are that good, it's better that they themselves go before a court and file a case and argue the case. There is no requirement to go before an advocate and engage him for a case at all. So the first thing you will have to put your foot down is the job of a client is only to provide you with the facts of a case. When it comes to law, you should be the decider and not the client. Probably the client may help you in getting some materials. I'm not talking about the ego part of it. It's possible that he may be able to provide you with 1 or 2 important materials which will be of help to you. But right from the beginning, you will have to make one thing very clear to a client, that he has come to you depending upon your professional standards and your professional efficiency. and he is not there to test you, or he is not there to project a case in the way he wants it to be projected, because he is not a specialist in that and he does not know how to do it. That is why he has come to you. But what is important is that if you start conceding it in the beginning, then going forward you will find it very difficult to really wriggle out of it and come out. If you find a client at the inception having an attitude like this, the first day discussion itself should be to lay standards on this. If you lay standards on this, the client knows where he will stop. You know to what extent you will entertain a client. If you don't do it in the beginning, you leave it, and after some time, if you attempt, normally it gets into a clash.
Okay, right. Now, all these things are off late. This video conferencing, how comfortable are you personally with video conferencing? As a medium for doing cases?
Yeah, frankly speaking, before all these started, we used to have video conferencing on certain cases where we would have decided something in Madurai, we would have decided something in Chennai. There will be some modification, relaxation, something which will come up where we would sit on a video conference. At that point of time, I used to tell my brothers and sisters that it's difficult to hear a final hearing in a video conference. Probably you may be able to do some clarification. You may be able to hear some urgent case for 5-10 minutes. You may be able to do some modifications, but it's not possible to conduct a full-fledged hearing in a video conferencing. Used to be my attitude before March. I'm talking about March 2020. After March, what happened was that unwittingly, I went into a lot of webinars. I started giving a lot of lectures and things in webinars. So my brain got mapped into this virtual hearing. Sort of, it became prepared for it. Therefore, after I started taking up cases for hearing, I found that I was able to do it sort of more comfortably than what I would have done before March 2020. So even without realizing that it is going to pave way for me to handle it more conveniently, I had got into this webinar mode for quite a long time, very regularly, looking at my own hideous face every time I'm talking. But ultimately, it actually helped me in conducting cases. Now what I find is that I'm able to do final hearing cases which goes to 2 hours, 2.5 hours in the afternoon and do it. Let me make one thing very clear. This is not a permanent solution. This is not an alternative for regular courts. Physical hearing must be the mode, must be the norm. This is an exception which is now happening. It's possible that we can identify cases which can be heard in this mode. It's possible that instead of going and troubling a judge in his residence on a Saturday or a Sunday, which involves an important urgent case, it's possible that we can have a video conferencing and do it. So it's going to open up some new vistas, but this can never be an alternative for a regular hearing, because in a video conferencing, your efficiency level, I would say, is only 1/4 of your total efficiency. By the time you finish it off at 5 o'clock, it is like running a 1,500 meters race. You are drained because of the shouting and this and that goes on.
When you're talking about efficiency levels being only 1/4, are you? No, this is a serious question.
Yes.
Is that the efficiency levels of you as a judge or of the lawyers, or both?
In terms of volume. In terms of if you are able to do 50 cases in a day,
numbers.
What you are able to do is only 20. It takes that much of time. What you will be able to do in an open court, only this much you can do in a virtual.
Okay, fair enough. Okay. Now you've also been sitting now for almost 2-3 months or 3-4 months on video conferencing. I'm sure there would have been extremely funny anecdotes, interesting things. Anything that can be repeated in a public forum?
Yeah, no problem at all.
Okay.
See, what happened was, this was one case where when the hearing was going on, I was able to hear the wife shout at the husband, saying, I was hearing sounds like that. So I was telling him that he has to go and either have his meen kolambu or he has to sit for the hearing. He cannot be doing both. And I told him that all of us get such terrible abuses from wives, but we are safer to mute it and keep it at a distance. You have exposed yourself so badly before a forum. And another case where I found that this person, the vessels, I was able to hear the vessels being washed in the house. So I told him that when you do it, please mute it and do it. Don't do it so openly, washing vessels to an extent where the judge is able to hear that you are washing vessels in your house. See, I basically feel that it's important that we should not expect a perfection at this point of time when it comes to video conferencing. And we should give a lot of leniency in this, because only now we are developing the skill of doing cases through video conferencing. And number two, there are lots of disadvantages that are there faced by the advocates in doing it. They are doing it in a single bedroom flat. What is that you are expecting as a background or as a dress which they are wearing, etc. So it's important that you do it with a lot of showing a lot of leniency. And even if you find something very serious, you make it more humorous and put across that to the particular person so that he does not repeat it in future, and the situation is not taken out of hands where he should not feel bad about it. I saw one person getting up and showing his armpit to me. See, he never knew that that the video was on, and he was not intentionally showing his armpit. The last thing he would want to show me is his armpit. So therefore, I knew that he was doing it without being aware that the video was on. So we are all trying to develop ourselves in this, and that's
so
it's basically you should have a humorous bent on.
So you're trying to say that from next time onwards, he eat his mean korambu and then come for the hearing.
Correct. Why would he combine both?
Okay. Okay. Now, a lot has been seen about your singing.
Yeah.
Okay. All these people have seen you singing over the last 2 years, 3 years.
Yeah.
I have seen you singing over 20 years or 25 years before.
Yeah.
And I also know that you come from a family of singers.
Yeah.
Well, isn't it a fact that most of your family were All India Radio singers?
Yeah, many used to sing. Correct.
Okay, now please hear this song.
Raja Solanna Yenayalu Padal Desam Meera.
Yeah. You, of course, know this song even more than either Mohan or K.J. Jesudas.
Correct.
Okay. We have spoken about continuity of juniors in office.
Yes.
Okay. But this kind of continuity, singing the same song, for the first time I saw you, you sang this song in 1995 or 1994. And singing the same song in 2018, 2019, 2020. Yeah, I mean, is there any specific reason that you have been singing only this song for more than 25 years? I mean, the reason that I'm asking you is, there is the story of this film is a slightly dubious one. I'm asking you whether you are trying to give a hint to anybody.
I think you have heard me sing only this song.
You have shown us only this.
You should go into the smooth part and you will find a lot of songs which I have sung there. So,
okay.
So these are things which are available in smooth also. So
there's no specific reason for only this song.
No reason, and please look at my face and say whether I'm capable of all that.
Okay. So apart from singing, your passion is, of course, music and the songs of Ilayaraja.
Yeah, that's right.
If I remember right, I remember you having told me a long time back that you accompanied him to some
yes.
East European country?
Yes.
Okay, so my memory is also right. Now, is it also not a fact that you play percussion instruments?
Yeah, I learned Mridangam for 3-4 years.
Okay, and do you still innamu Mridangam vasikradunda?
இல்ல உஷா தான் வாசிக்கிறேன் என்ன பட் எனக்கு வந்து அந்த rhythm pattern is something which naturally I have an interest towards. Konnakol.
Are you still sort of
No, I can. Basically, tam katak dim dimna dim dim tergada dim dimna tam katak dim dimna dim dim tergada dim dimna. I can just like that come up with that. If you have time, I can do it for 2 minutes like that. If you have time.
Of course.
Tam tarigadagadam 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 so I can, these are things which came sort of naturally to me. So even today, without a practice, I will be able to get into things like this.
With this, your singing and your ability to play a percussion instrument is surprising that you did not go into Nattuangam.
Yeah. See, basically what happened was that it all stopped with a particular, at a particular stage. Everything was stopped. Meaning I did not pursue it seriously. There were certain other things which started coming into life. So therefore, all this went off. But I will not regret for any of these things, because even now there are lots of things which keeps me interesting, which makes me interesting, or which brings interest to me, like music, like rhythm pattern, etc., etc.
Okay, right. You have been known to be a cricketer.
Yeah.
Okay. Now you are more seriously into fitness now.
Yeah.
Now, how important is fitness how important was fitness for you as a lawyer, and especially now that you've become a judge, especially since ours is a slightly sedentary profession.
Yes.
We might say we are very active and all that, but it's basically a sedentary. How important is that?
See, basically, I was born obese. I was an obese person for a very long time. So, as you know, during our times, people who are obese, they were treated very badly in the society. The first thing that happens is that a person who is either handicapped or a person who is obese, they will be the first target for making fun. So, therefore, I wanted to first plug that. I was not able to take it anymore. So, I got into cricket. I started getting more active into sports and all that. After a particular point of time, cricket became impossible. I was not able to really get time to go and play a match for half a day or full day and all that. Then came the fitness regime. Fitness, I got into very serious fitness as early as in 1999. From 1998 or 99 onwards, I am going to a gym and working out. Meaning, if I had not become, I used to tell many people, if I had not become a judge, I would have become a good fitness trainer. I know the in and out of the weight section and what is done for which muscle, etc. So
were you also a runner?
I used to train myself for veteran athletics when I was 35 and all that.
No, I have a very interesting question to ask. Since you mentioned that your fitness regime started in around 98, 99 and it included running as well, does it have any coincidence with your year of marriage, etc.? Because immediately after your marriage, you seem to have started running away.
I think I cannot answer it in a forum like this. But I have been trying a lot of things. I tried to do athletics. Actually, athletics I started at the age of 35. You won't even believe it. Then thereafter I had a knee problem. Then I got into a regular workout in gym, which I continue to do it till now. I always believe that fitness is very unless and otherwise you are bodily fit, you will not be having that energy to handle things. You will not be having that freshness to handle things. So unless and otherwise a person is into fitness, unless and otherwise a person is able to control his own body, forget about he trying to control his emotions and mind.
True. Okay, that's a good one. I also know that you are a voracious reader. Regular books on philosophy or spirituality?
I started reading books only from 90s, after 90s, and it all started with spiritual books only. I started only with spiritual books, and And even now my collections are 90% of it is only spiritual. This is something which nobody knows. So I had all sorts of this Upanishad, this and that, I have it. My reading is basically serious reading. In the sense that when I take a book and read, I'll have to tell you that I have not read a novel at all till now. What I have read is only serious books. When I take a book and read, I always expect that I'll have to learn 1 or 2 out of it. There must be something which it should teach me. If it does not happen, then I don't really go near them. So that's how I keep reading books. So I have slowly expanded its vistas to autobiographies, to some of the books written by doctors. It has now gone into this intelligence, artificial intelligence, etc. So varieties, large varieties.
Right. And now we come to the most boring kind of reading, which is law journals. Okay. I saw the earlier video in which you said on the Saturday evening when the journal padikalana when the hand starts shivering.
Correct.
Okay. Today is Sunday evening, so hands would have started shivering at around 5 p.m. But how important is this reading of journals? Amidst all this humor, how important is this reading of journals for youngsters? Because I never had this habit.
Okay.
Though my father did. I never had this habit, but apparently you've had this habit. How important is this for youngsters?
It's very important for youngsters because it's impossible to get yourselves exposed to various fields of law by just taking a book and reading it. Because by the 5th or the 10th page, you will feel sleepy. But when you read a journal, the biggest advantage that you have in a journal is that the journal will touch upon varieties of laws that are involved. One case will involve a transfer of property, another case involves a contract, another case involves something else. So the journals basically have varieties in it. So if you are able to pick up a journal involving criminal law, a journal involving constitution, a journal involving civil law, and an SEC, by the time you realize you would have done it for 10 years, 15 years, and even without you realizing, you would have exposed yourself to lots of areas in law. Actually, you would have understood lots of areas in law. And thereafter, if you want to really understand about what was dealt with in that journal in that particular case, it's good to go and pick up a commentary and read it. I used to follow this way of reading it rather than sitting and reading a commentary and getting into this, because as a first generation lawyer, I had to handle whatever cases comes to me. There was no choice at all. So what happens is that I love to pick up journals. I love to acclimatize myself to a lot of things. The only area where I did not really practice is tax. Apart from that, every other area I practice. So I had to sort of update myself on law. Journals are the one which really helped me. And even today, what is seen as a big sort of positive, insofar as I am concerned, is my knowledge and updation of law. Meaning, sort of, I will be abreast with the latest development.
Okay. It has also come to my ear that you're a foodie.
Yeah.
And that you follow my policy whenever you go for weddings.
Yeah.
Go straight to the dining hall, finish your food.
Correct.
And then if the stage is not too crowded,
correct,
we can go see the married couple.
That's true.
Offer our felicitation. Is that right?
That's true. That's true. That's true. The first thing I do when I enter into a marriage hall is go directly to the dining hall. Because, see, the first purpose is actually that. Second is to wish the couple and all that, if I have time. So, the first thing you have to do is you have to go and eat. And then, with a lot of energy, you can thereafter spend time with those who have come there. And yeah, it's true that I have a weakness for sweets. I used to have a lot of weakness for sweets and all that. But since I was putting on weight, I have cut down on that. But even now, on the one hand, I will scream at Usha if she makes some sweets. But ultimately, at the end of the day, I will be the person who would have finished off the whole thing.
I believe there are fights between you and Ramanan as well when sweets are made.
One area where I have a lot of problem with my son is that he keeps eating everything. I have told her that when you do one separate for me and one separate for him. I will compromise on anything, not on these things.
Not on these things. Okay. Okay. Affection for the son only goes that much, is it?
Correct.
Okay. Right. Ravichandran, to whom I spoke a couple of days back,
Yeah.
told me that you were a workaholic.
Yeah. That's
okay.
Right.
And 24/7, 365 days a year.
Yeah.
On a serious note, has it ever affected your health in any way? This constant work?
No, it was a love affair between me and law.
True.
So when you love somebody, it's actually 24/7 and 365. You don't feel tired at all. Same was the case with law also. It was a passion-driven thing for me. What makes me do all this is only passion. I don't see it as a work at all. For me, it's all. The more I get, the more I plunge into it. So if you look at it from a work point of view, people may think that I am workaholic. I am not. According to me, I am not. I am doing something which I like and love to do.
Okay. I love that statement of yours. Even with the law, it was that way.
Yes.
Even with,
yes.
I love that. Okay. According to you, how good is memory for a lawyer? Memory.
I have a very bad memory. Basically, for me, it's all jotting down. For me, it's all. I will forget names of persons who I know well. I will forget words in English about which I have dealt with for a long period of time. I will forget numbers. So memory is very important for a lawyer. But then it does not mean that if you don't have that ability, you cannot do anything. You have to find ways and means as to how you will be able to overcome that. But memory, of course, is very important.
Okay. The reason I asked you is, do you remember spoiling the career of anybody in your life?
In this profession.
No, in your life. There was this wonderful cricketer in law college. And you injured him and ensured that he did not become the next Ricky Ponting.
I know when you got one from me. I was a fast bowler at that time, and our law college ground used to be sort of pumping. Yes, correct. Yeah. I know that you got one in your thigh.
I couldn't move for the next 3 hours.
But I would say that on a serious note, as I always say in any forum, probably I came in the way of Usha's career.
Okay.
I would say that. Without any hesitation, I would say that.
No, because having known both of you between 92 to around 98, 99 pretty well, at which point of time each had their own commitments and therefore we went in separate directions. She was the more talkative, she was the more active. And not to say that you were the follower, but she was definitely the more active of the two of you.
There is no doubt at all. There is no doubt at all. See, before meeting Usha or before Ramanan was born to us, I would say I was a very different person altogether. It is after I started understanding Usha well and after Ramanan was born to us, I have developed or I am attempting to develop a lot of finer aspects in life. In terms of emotion, in terms of expressing yourself, in terms of talking your emotions, in terms of understanding the feelings of others. These are things which actually I acquired only after post my marriage with Usha, post the birth of Raman. So therefore, to that extent, I would always see both of them to be my gurus. I would give them the status of a guru. When it comes to inculcating, when it comes to me imbibing the most important facets of life, namely the finer aspects of life on emotions and feelings, etc., which I never had. I was the most selfish person in the whole world. And I have no hesitation to accept that also. Sharing emotions to to appreciate others. These were traits which I never had. I was like a rock, basically. And these are the two guys who came and chiseled me, and what I am today is only because of them. If you are able to find some good traits in me, if you are able to find some interesting traits in me, the whole credit must only go to them.
Okay, and surprisingly, we've now come to my last question for
Jambulingame jadadara, Jyotilingame arugara, Vayulingame adabuda, Panjalingame madabada. Vayulingame sadasiva, Panjalingame mahadeva, Jambulingame jadadara, Jyotilingame arugara.
Thank you, Bilson.
You touched a raw nerve, no?
No. What most people don't know is you spend more time talking about Tenga Srinivasan than about any law.
Correct.
Okay. Now, I know probably most people don't know that Tenga Srinivasan is our favorite.
Correct.
Okay, and your favorite. You watched more hours of Kasedan Kadolada and Thillamulla
Yes, yes.
than any other serious thing.
Yes.
Okay, right. Now, to see whether you have done your research like your law journals on Kasedan Kadolada is the question.
Okay.
Tenga Srinivasan, M.S. Viswanathan, Chitralaya Gopu. So the questions are not about them. Who were the singers
In this
song?
That's interesting. I never realized that I'm going to get bowled out of this. You tell me the answer.
One is Tenga Srinivasan's voice is Ayyappan Padal, K.
Correct.
Veeramani.
Correct.
The other is not T.M. Soundararajan.
Ah.
It is Dharapuram Sundararajan.
Oh, I see.
And Kovai Soundararajan.
Uncover Soundararajan. I see.
I thought you would know this.
No. I was more enamored by Tenga Srinivasan.
But
I never classed Tenga Srinivasan in that time. When it comes to Tenga Srinivasan, I don't really
Look at
focus on anything else. Focus on anything else.
So therefore, in the last 10 seconds of that song, you would have noticed on the Kannadigardu. And for what reason? But Justice Anand Venkatesh, thank you very much. I never thought that on my session, I would have enjoyed such a serious session. You've made it so serious. It was such an intense session with a lot of takeaways. So it is now 7:15, 7:20.
Yeah.
Would you like to take a few questions?
No problem.
Okay. Now the first question is sent by mail from Mr. Ravindran, Senior Advocate, S. Ravindran, Senior Advocate.
Yes.
S. Ravindran. Your advice to youngsters, would you advise them in respect of general practice or specialization? He's talking about probably raw juniors.
Definitely for a first generation, it is general practice. I always believe that it's not good to confine yourself to a particular field to start with. Probably as you go forward, it's possible to specialize on something. But it's important that you get exposed to all fields of law. Or else, I always felt that if a person is not exposed that way, he is half-baked.
Okay, right. Thank you. So the second is from, also by email, is from Gomati, who's doing a wonderful job of attending many webinars and keeping herself updated with a lot of information. She's an assistant professor of law at Shastra University. Okay, her question is a rather interesting one. An essential quality for a judge is compassion.
Yes.
But since the topic is in respect of a successful lawyer, her question is it also required for a successful lawyer, the element of compassion?
Compassion is something which is required for a human being if a person has to call himself as a human being in this earth. Compassion is that. Empathy is that. A person without compassion and a person without empathy does not even fit into the term called as human.
Okay, that's fair enough. The next thing is by Sanjay Pinto, also by email. Sanjay is asking us for advice, and therefore, Sanjay, we've given our bank details. Please swipe your card or make payments. We're not giving advice free. Sanjay's question is, you know, Sanjay there was, resident editor for TV, etc. He joined, though he qualified as a lawyer pretty early on.
Yeah.
He joined only after 20 odd years.
Yeah.
Okay. So his thing is, people join after retirement, resignation, etc. Okay, though they qualified earlier.
Yeah.
Such people are too old to join a senior.
Correct.
Any advice on sourcing of work?
I think, see, basically what happens is that, let us take 2 or 3 instances of where I've met people like that. People from insurance companies, people who have been working in secretariat, etc., where they'll be exposed to a lot of these rules, circulars, bylaws, etc. People who come, who have been law officers in some departments, people who have been working in registration departments, etc. See, what happens is that you have a distinct advantage with people like that because they know a lot of important circulars or important things which is involved in the department. They also understand the psyche of a department, basically. So you can have people like that with you who will be of a lot of great importance to you, provided they are willing to join you. But if they try to come independent and argue before court, they'll be thoroughly disappointed because they don't have court exposure and they don't have the capacity to handle a court. The way in which they put it and what the court is expecting will be 2 different things. So for people like that, it's better that they get into an office and they should be of a lot of assistance to people who have already established themselves. And probably at some point of time, they can start doing some cases.
Okay. A person who's raised his hand now is Mr. Ayyapamani.
Yeah.
Yes, Mr. Ayyapamani, please unmute yourself and ask. Sir, you will have to unmute yourself as well.
Yeah.
Yes. Solunga.
Yes, sir. Sir, good evening, sir. Good evening, Lordship.
Good evening.
Sir, I'm sorry, my delay may be condoned. I came only at later stage. I'm not able to get connected. The only doubt as a Lordship has observed that 24 into 7.
அந்த லார்ட்ஷிப் விட்டுடுங்க.
Yes, sir. ஐயா சொன்ன மாதிரி இந்த ஒரு விஷயம் நான் இந்த ஜஸ்டிஸ் இப்ராஹிம் லைஃப்ல வந்து பார் கவுன்சிலுக்கு வந்தப்போ ஒரு விஷயம் சொன்னாருங்க. ஃபிட்னஸ் இஸ் வெரி இம்பார்ட்டன்ட் ஃபார் a successful lawyer அப்படின்றது. நீங்க வந்து ஃபுல்லா இப்ப ஃபிட்டா இருக்கிறதுக்கு யோகாவா என்ன ரீசன் உங்க சீக்ரெசி?
சார், அவங்களுடைய அவங்களுடைய பிராக்டிஸ பொறுத்து. இப்ப ஃபார் இன்ஸ்டன்ஸ், நான் ஆரம்பத்துல இருந்தே ஐ ஹேவ் பீன் கோயிங் டு திஸ் ஜிம்னாசியம்ஸ் அண்ட் ஒர்க்கிங் அவுட். சோ அதனால வந்து எனக்கு ஐ வாஸ் மோர் இன்டு தி வெயிட் செக்ஷன், weightlifting section and all that. I'm used to that, and I'm used to some cardio exercises. I also used to combine with a lot of yoga postures and all that.
Okay.
But it all depends. Enna porthavarikku fitness evlo dooram porumna, daily walk for 1 hour, do some stretching exercises. That is more than enough because there is no requirement to show a 6 packs at this point of time.
Okay.
So
இன்னொரு டவுட் லார்ட்ஷிப், நாங்க லீகலா இப்ப நாங்க மஃப்சில் கோர்ட் அட்வொகேட்ஸ்க்கு எல்லாம் வந்து ஹை கோர்ட்ல வர ஜட்ஜ்மெண்ட்ஸ் தான் நாங்க டோட்டலா ரிலை பண்ணி போயிட்டு இருக்கோம். டோட்டலா எங்க கிரிமினல் சைட் பிராக்டிஸ்னஸ் எல்லாருக்குமே வந்து ஹை கோர்ட் ஜட்ஜ்மெண்ட், சுப்ரீம் கோர்ட் ஜட்ஜ்மெண்ட் தான். இப்ப பாத்தீங்கன்னா நீங்க வந்து போக்சோ ஆக்ட்ல வந்து எல்லாமே கன்விக்ஷன்லயே வருது லார்ட்ஷிப். ஒரு ட்ரையல்ல வந்து நாங்க நடத்தினாவே கன்விக்ஷன்றது ஒரு ஸ்டேஜே வந்துருச்சு டோட்டலா. அது வந்து டிபெண்ட்ஸ் அப்பான் தி ஃபேக்ட்ஸ் ஆஃப் தி கேஸே பாக்குறது இல்ல யாரும். போக்சோனா கன்விக்ஷன் தான் அப்படின்ற மாதிரி ஒரு ஜெனரல் ஒரு பிரசிடென்ட் மாதிரி போயிட்டு இருக்கு லார்ட்ஷிப். சக்சஸ்ஃபுல் லாயர்னா இங்க கிரிமினல் சைட் ஃபிளவரிஷ் ஆகிறதுக்கான வாய்ப்புகளே குறைவே ஆயிட்டு இருக்குன்ற மாதிரி மஃப்சில் கோர்ட்ல நாங்க ஃபீல் பண்றோம்.
வாட் எது முக்கியம்னாக்கா சார், நீங்க போட்டிருக்கிற கேஸ்ல வந்து நீங்க ஜெயிக்கிறீங்களா தோக்குறீங்களான்றது வந்து சக்சஸுக்கு அது சம்பந்தமே கிடையாது.
இல்ல கண்டிப்பா
சம்பந்தமே கிடையாது அது ரெண்டுத்துக்கும். எது முக்கியம்னா நீங்க கொடுத்த கேஸ உங்களுடைய பெஸ்ட் இதுக்கு நீங்க பண்றது ரொம்ப முக்கியம். பட் இப்ப இந்த பர்டிகுலர் கொஸ்டினுக்கு நான் வரேன். இந்த போக்சோ பொறுத்த வரைக்கும் நான் என்ன சொல்றேன்னாக்கா, போக்சோ provisions are intentionally kept to be very stringent because the persons involved are children அப்படின்றதுனால. So what happens is that the court expects that a child will not come and lie before a court. The child will not be able to explain a particular sexual act in the way it explains without actually experiencing it. ஒரு 8 வயசு பையனோ 10 வயசு பொண்ணோ அவங்களால வந்து under normal circumstances they will not be able to explain it this way. So in the Poxo Act ellame vandu the concept is to safeguard the rights of children. Therefore the level of proof has become very stringent there. So adanal the judge is a human being. I am again and again saying that don't think that the judges who are sitting are some robots. They are human beings. Every judge has some preconceived notions. Every judge has some emotional levels. Every judge has his own ego. Ellame irukum. A successful lawyer is the one who finds out the truth in a case and puts it before a judge. A successful lawyer is not the one who makes a real criminal escape. Probably உங்களுடைய career-க்கு அது பிரமாதமா இருக்கலாம். But வாழ்க்கைக்கு அது எவ்வளவு தூரம் ஓகேன்றதுல வந்து I have my own views about it.
இல்ல நீங்க உங்க ஜட்ஜ்மென்ட் தான் வந்து மதர் வந்து ஃபால்ஸ் கம்ப்ளைன்ட் கொடுத்தது நீங்க தான் வந்து டிஸ்கஸ் பண்ணிருக்கீங்க டீடைலா டிஸ்கஸ்.
ஆனா லாயரோட வேலை என்னன்னா ட்ரூத் எக்ஸிபிட் பண்றது கோர்ட்ல. அதுதான் லாயரோட வேலையை ஒழிய ஜெயிக்கிறது தோக்குறதுன்றதெல்லாம் வந்து that is far away from all this.
Okay Lachip.
Thank you Mr. Ayyapamani. Next we have in all these sessions, we have these usual suspects raising their hands. Our usual suspect is V.S. Jayakumar. Please. Yeah. Wilson, can you unmute Jayakumar, please? Yeah.
Sriram.
Yes, sir. Yeah, you are audible.
Yeah.
I'm not the usual suspect.
Give the benefit of doubt to Sriram. Yeah.
Yeah, this is about art of advocacy in a live hearing and virtual hearing.
Yeah.
Especially in a division bench. See, what happens is, of course, I'm appearing in 2 judges, 3 judges and all that. Which judge I must see the eye contact, I really don't know. Past 30, 40 years.
Yeah.
And virtual hearing, it's horrible.
Correct.
So I want to know, where do I look at the judge eyes in the virtual hearing?
See, actually, one very important aspect that is taken away from virtual hearing. That is why I started saying that virtual hearing must only be an exception and physical hearing must be the norm. There is no doubt about it at all, because the most important aspect of advocacy is only in the physical hearing, where you look at the eyes of a judge, where you look at the reactions of a judge, where you look at the body language of the judge. You look at a lot of things that are actually happening. And ஒரு வழக்கால தான் இன்னொரு வழக்கை ஏத்த முடியும். That is possible only when it is a live hearing. நீங்க எவ்வளவு பெரிய அழகான வழக்கா இருந்தாலும் உள்ள ஸ்கிரீன்ல இருந்து ஏத்துறது கொஞ்சம் கஷ்டம். Because it is important that 2 human beings physically interact. அதுக்கு இருக்கிற ஒரு இம்பாக்ட் வந்து ஒரு ஃபோன் கால் கூட இருக்காது. இப்போ நம்ம போன்ல ஒரு விஷயத்தை பேசுறோம், இல்ல மெசேஜா ஒரு விஷயத்தை அனுப்புறோம்னு வைங்களேன், அதுக்கும் பிசிக்கலா 2 பேர் பேசுறதுக்கும் பெரிய வித்தியாசம் இருக்கும். அதனுடைய இம்பாக்ட் இருக்கும். அதுல வந்து there is a lot of human interactions or certain things which passes on between 2 individuals which can never happen in a virtual platform. So therefore that aspect of advocacy is completely lacking. There is no question of looking into the eyes of judge and all that. If you keep staring at the judge க்கு பயம் வந்துரும். ஏன் நம்மள பாட்டு திருக்குறுன்னு முழிக்கிறானேன்னு சொல்லிட்டு. So அதனால வந்து what I feel is that virtual hearing பொறுத்த வரைக்கும் வந்து it will be useful only in certain types of cases where it involves more of documents, it involves more of appreciation of documents, etc. But when it comes to cases, criminal cases, when it comes to cases where you are putting forth some important questions of law on a constitution, on a tax and all that, you require physical, or else it will not work. It will not work according to me.
In a physical hearing, my lord, the division bench, which judges I must see, the senior judge or the junior judge?
In a physical hearing, right?
First, when a judge asks a question, I can look at him. But I don't look at the all.
In a physical
I
hearing,
don't look at the junior judge at all.
In a physical hearing, what happens is that, let me tell the human tendency. In a bench, an advocate tends to look at a judge who speaks more.
Quite right.
An advocate tends to look at a judge who interacts, who opens up with his opinion about certain things. So the natural tendency will be to look at that judge. Just two. But I would always say that if both are equally doing it, it's better that you, like how you speak in an audience. When you address an audience, what do? You keep looking at everyone and keep speaking. You don't fixate your eyesight to a particular person when it comes to an audience. Same way, when it comes to addressing a bench, etc., if you find that there are two judges who are equally sort of interacting with you, it's easy to look at both of them and argue. But the tendency is you will be looking into the eyes of a judge who actually interacts, who actually opens up. So therefore, that's a part of advocacy. That's all psychology. It's basically psychology.
Thank you, sir. Very nice.
Thank you.
Okay. We now have Abrar.
Yeah.
Abrar, are you there?
Yeah, he's there. He has to unmute.
Good evening, sir.
Yeah, good evening.
Host disable பண்ணிருக்காரு.
இல்ல கேக்குது நல்லா.
Okay.
No, he meant his video.
Video.
Yes.
That's okay.
Abrar not only wants to be heard, he wants to be seen as well.
அதெல்லாம் வேண்டாம். ரொம்ப சந்தோஷம்.
Yeah.
ஒண்ணும் இல்ல. When we were practicing,
yeah.
I used to tell you, எதிர் சைடுல வரும்போது வந்து நீங்க தயவு செய்து சிரிச்சிராதீங்க அப்படின்னா, I know you are going to drop a bomb against us.
Correct.
என்ன? Luckily, you are not following that after you've been elevated.
Yeah.
Now, was there, my question is out of the, was there any judge you dreaded appearing before?
Yeah, Justice Raviraj Pandian.
Oh, okay.
Because for some reason I was not able to really sync with him.
Okay.
And I was not able to succeed even in a single case before.
Okay.
So I would say that I found him to be difficult.
Okay.
Yeah.
Okay, sir. Thank you.
You never expected me to answer this question, but then you are addressing a very different person here.
Thank you.
அவன் பதில் சொல்ல முடியாது சொல்லிட்டு தானே அந்த கேள்வியை கேட்கிறான். Okay, thanks Abrar. We now have Ajay Loyola.
Yeah.
So you're able to hear me?
Yeah, we are. Could we see you as well?
Good evening. Yeah, sure. As I don't want to be embarrassed by showing my armpit or something like that, but it's okay.
No, as long as
now I'm used to it. Hopefully,
as long as you don't frighten us, it's okay.
Hopefully it stops there.
Yeah. Another thing, a person was smoking in front. It came in the papers. Very embarrassing, but we can have a light chat because it's a coffee time and now it's gone almost to dinner time. Coming to the question, sir, this is regarding how to handle clients in terms of, for example, it's a live case for me and I have argued and also filed my counter. And then mostly the written statements is only a slightly a different third degree kind of a you change. But the client now has awakened and he wants a change of wakalat and he says, I'll find somebody else who is a friend of mine and you know, he wants to withdraw and how do you handle this?
See, basically both the judge as well as an advocate must realize one thing. They both are involved in a process where they are deciding the rights or they are deciding the fate of a person who has approached the court. So these two are only enablers. The advocate is an enabler, and the advocate is an enabler in the sense that he puts it forth to the court, and the judge is an enabler to the extent that he decides it. But it all depends upon the confidence level which a client has on his advocate. The moment a client says that he wants to change his advocate, you should not even be having that paper for 1 more second. It should be immediately handed over. It may be for 100 reasons. He would have virtually squeezed you for all your work. He would have taken you, etc. But it all depends on how smart you are. It all depends on how you have already taken your fees. That smartness portion of it, I'm not talking. I'm only saying that at the end of the day, if you find that your client has such intentions, you'll be easily be able to find out that. Once you find out, the best thing would be to hand it over. Never hold a brief where a client does not have confidence in you even for 1%. If you hold such a brief, what happens is your life will be a misery, his life will be a misery. And with today's type of clients, you may land up in a very, very big problem. So therefore, what is important is you, at the end of the day, you should be peaceful and happy. If that is going to bring you unhappiness, rather get rid of it.
Thank you, sir. Thank you so much.
Yeah.
Okay, thanks, Ajay. Next person to raise a query is V. Vasant Kumar. Vasant? Wilson, can you unmute Vasant, please?
Yes, sir. I given a point.
Yeah, Vasant? Vasant, are you there?
Yes, I am there, sir.
Yeah, Vasant.
Sir, good evening, sir.
Good evening. Good evening. Tell me.
Sir, I know a doubt now, sir. We are conducting cases from trial court and high court. And we are succeeding in both the courts. The matter is taken for SLP. For some reason or other, we could not go to Supreme Court. We are handing matter to the Council of Delhi. And ultimately, the matter ends up in failure. If is there any thought to you saying that because of some work at Madras, some geographical disadvantage could not go to Delhi? What thoughts are what would be?
Vasant Kumar, what is important is this. At least I believe in this. Every bundle has its own fate.
Yes.
Every bundle has its own fate. அதுக்குன்னு ஒரு ஏற்கனவே அதுக்காக ஏற்கனவே நிர்ணயம் செய்து வச்சிருக்கிற ஒரு விஷயம் அந்த பண்டில்ல இருக்கிற ஆளுக்கு நடக்கும். நம்மளை பொறுத்த வரைக்கும் நம்ம வேலை என்னன்னா, we have to do it as best as possible. And the rest of those things, yeah, you may get a feeling that probably if I had gone and done it, probably it would have been a different. The fact that you were not able to go on a particular day itself must tell you that there is a fate which is playing there. You are only supposed to argue that case. On a given day, for some reason, you are not able to go and argue it. Somebody else goes, it goes before a bad judge, and something happens to that case. What I feel is that it had met its fate. அதுக்கு மேல நீங்க அதுக்கு அர்த்தம் கண்டுபிடிக்க ட்ரை பண்ணீங்கன்னா, எவ்ரி கிளையண்ட்னுடைய பண்டிலுக்கு நீங்க அந்த மாதிரி அர்த்தம் கண்டுபிடிக்க ட்ரை பண்ணீங்கன்னா நம்மளுக்கு பைத்தியம் பிடிச்சிடும். We will get mad. So it's important that அதுக்கு பேர் தான் ப்ரொஃபஷனலா இருக்கிறதுன்றது. ப்ரொஃபஷனலா இருக்கிறதுன்னா ஈவேரக்கம் இல்லாம இருக்கிறது இல்ல. ப்ரொஃபஷனலா இருக்கிறதுன்னா to maintain that detachment from that bundle and from that client. Only if you maintain that detachment, you will be able to perform your role as an advocate for the client, as an officer of the court, as an important instrument for this institution. If you get attached to any of the cases, you will not be able to perform the rest of the two things. And you will find it in many cases where advocates become too emotional about the case and all that. Yes, when it comes to fighting for justice, you will have to fight it tooth and nail. There is no two ways about it. I will openly say that in some cases where I have seen Vaigai senior advocate, I have seen Prasad doing it, I have seen lots of people doing it. There is absolutely nothing wrong in doing that. You have to fight for your client. But at the end of the day, after doing that, you will have to just leave it to the the judge and to the fate. You should not get more involved into it, because you will unnecessarily get into mental problems if you start developing that.
Thank you very much, sir.
Yeah.
Even K.K. Venugopal also told like this only when I was doing the National Court of Appeal matter.
Okay, okay.
2 or 3 times it was not materialized before the full judge bench.
Yeah, yeah.
Thereafter we have about 3 judgments that refer to the constitutional bench.
That's right, that's right.
K.K. sir told me don't get disheartened because the matter is not getting reached.
Yeah, Mr. Vasant Kumar, you would have seen cases where you would have argued before a particular judge. The judge would have been prepared to allow your case. For some reason, you would have got adjourned. It will go before a different judge, and that judge will be completely against you, and he will dismiss the case.
Yes.
Have you not seen that?
Yes, I find, yes.
Yeah. So that's it.
Yes.
When it involves human beings, all these things will happen.
Thank you, sir.
Yeah.
Thank you, Vasant. Thank you, Vasant. Next, we have one of the brighter youngsters, Sri Charan. Sri Charan.
Yeah, good
evening, sir.
Yeah.
So we've not had a chance to interact before, but always one thing that Mr. Sriram says, or rather the carrot and stick approach. Carrot is that I'll give good sessions provided you don't ask for advice here. So I'm not going to ask for advice. It was a very interesting session, sir. 2 things, sir. You were talking about on a serious note. You also spoke about webinars that you've been addressing. I've had a chance to attend some of your webinars, and I was thinking that this is a very serious person that we are having as a judge, and it was nice to see you in this form as well.
Yeah.
But in I think I was more captivated by the Tenga Srinivasan in Tilmula, that Lana Varadu, Sanam Varadu, Permutu Subramanian. So I think your yes, so on my question is, when Mr. Sriram asked about what is your measure of being a successful advocate, and you also mentioned that you never thought that you would be made a judge. So my question is twofold. Part A is, advocate probably you felt that, okay, I do my brief to the best of my ability, therefore there is success. If I can justify myself, I can look at the mirror and say that I've done justice. But having become a judge, what is your takeaway? That is part 1. And how would you measure success there?
Success for whom? For a judge or an advocate?
For a judge. Okay. When you're wearing the hat of a judge now.
Okay.
And part B being this, sir. Being a judge, according to me, is a thankless job, because at the end of the day, I mean, we can't please anybody, and that is not a judge's work either.
Yeah.
So what is your takeaway when you decide a case? So on one hand, success, and on the other hand, what is your biggest takeaway being a judge?
Okay. First, I'll talk about a successful. Yeah, thank you. First, a successful judge. There is nothing called a successful judge, according to me. For me, I will be very satisfied in my tenure as a judge if I have rendered justice to the most ordinary person in the society. For a Kupusami and Musami, if I had rendered something to them. For a person who is very poor, if I had rendered to them. For a person who was craving for justice, if I had given some justice to them throughout my career. If I had been, if I am compassionate, if I empathize myself with the person who is standing and asking for justice, and I have done my best for him, I would say I would prefer that more than me writing judgments involving case laws, judgments involving legal provisions, judgments involving some big legal questions and all that. If you ask me to put both, I would always prefer to be a judge who would want to reach the last man in the society, who would want to go and reach the man who approached the court believing that he is going to get justice before a court. That is the person whom I target. He is important for me, because a person who is powerful, a person who is having the wherewithal, even if he does not succeed before a court, it's possible that he may succeed elsewhere. He may sort of blunt it. He may sort of stop it by doing something else. But a man who comes before the court, for him the start and end is only the court. For a person like him, whether it is on the service law, whether it is on the criminal law, whether it is on the civil side, whatever it is, he must feel at the end of the day that he had his complete, he was heard in full, and the judge came to a conclusion. I would have allowed it, I would have dismissed it, but that's not the question. When he goes out of the court, he must feel that, yeah, I tried my best. I put my case, my entire case before him, and this is the judgment which he has rendered, which according to him is right. If he goes with a feeling like that, and if I have done it throughout my tenure, for the coming tenure, I would feel that I am a successful judge. I have no other aspirations here. I'll put it very, very clear. These aspirations, this becoming that, all that is complete. This moonshine defense is something you would have heard in a summary suit. I feel it is that. It is that. So therefore it's moonshine. At 62 or 65, when you're out of this, you and other Kupusami and Munsami roaming around in the court, in the streets. So therefore, I find that this is the success rate insofar as I am concerned. The second question which you asked me is with regard to, what is that? Just repeat. Yeah, unmute.
Yeah. Sir, I was talking about this being a thankless job.
Yeah.
So I think.
Yeah. So, insofar as that is concerned, I'll give a very serious answer for this. I believe that if you are not destined to sit as a judge, whatever attempts you may make, it's not possible to sit in this seat. This seat has some speciality in it. What is that speciality? I will not be able to explain it. It's like you getting into a particular seat and thereafter something else takes over you. Thereafter, it is not Sri Charan, it is not Sri Ram, it is not X, it is not Y, it is not Advocate General, it is not Attorney General, it is the issue before the court. I'm telling you the truth. So, there is a destiny which plays in the person becoming or taking up this post. Once you take up that post, what you are doing is that you are deciding the fate of somebody else. So it is not a work which you are doing. It's a big responsibility that has been put on you. You can never equate this responsibility in terms of money. You can never equate this responsibility in terms of anything. It is so divine. It is absolutely a divine experience which you are undergoing. So there is no question of thankless and all that. It's like saying it's like saying that what has God got to do with being thankful or thankless? If you believe in God, it's that. So therefore, when you take up this post, you must be prepared for 2-3 things. One, you are going to get a fixed salary. Whether you work more, whether you work less, whatever you do, this is the one which is going to come and sit in your bank account every month. Number two, the more you work, the more you will be loaded with work. This is human nature. It is human tendency. The more a person works, it works in organizations, in company, wherever you go, you will find that people who work, it will be loaded on them. So you must be prepared to take that load. You must not be seeing it as a work. You must be seeing it as persons who are sitting there and craving for justice before you. That responsibility is there. Number three, you should develop a lot of patience, compassion, and empathy for people. If you do that, what happens is that even though you may get angry in a particular case, even though you may get very agitated in a particular case because the way in which the advocate had irritated you or something had irritated you, you will not show that irritation on that bundle. Unless and otherwise you possess these traits which has to be developed, sir, it is not automatic. Nothing here is automatic. Everything is a conscious development of these traits. If you develop these traits, I think you can have a really not successful, satisfying tenure. There is nothing called as successful. At the end of the day, you must be satisfied with what you did. That's what I told even for a successful lawyer. Same thing I am saying for a successful judge. Our satisfaction with what we are doing is the most important thing in the world than what the world is thinking about it.
Thank you, sir.
Yeah.
Very profound.
Yeah.
Sri Charan, satisfied?
I am.
Yeah.
But
No.
it takes a lot of maturity to get there.
No. I'm telling the speaker, Sri Charan is asking you to the definite. You made up your plans now. Thanks, Sri Charan. Thank you. Yeah. It's only when you ask such interesting questions that such interesting answers also come. And the last person to ask a question is probably the youngest Turk on the turf. Vishnu, come.
Yeah.
Good evening, sir.
Yeah, Vishnu.
Sir, whom do you look up to in this profession apart from your senior? One. Second question is, taking a cue from your earlier replies, when you are faced with an issue like equity versus law,
Vishnu, please repeat your question. Vishnu, please repeat your question.
Yeah. Who is your mentor in this profession apart from your senior? One.
Okay.
The second one is, taking a cue from your earlier reply, if you are faced with a situation where you are put up with an equity on one side and the law on the other side, which one would you follow?
Okay. The first question is that I have a lot of mentors actually. Obviously, it's my senior. Then I have seen certain senior advocates perform in court. I would say P. Chidambaram. I have, from a distance, I have admired a lot of people. Vaigai, Muthukumarasamy, R. Krishnamurthy, M.S. Krishnan, Vanamamalai. People should not think that I'm leaving names, but I have seen a lot of people from whom I have really been inspired, and I have really learned certain nuances of presentation in court and all that. Each person had his or her own trait of doing it. So I have learned a lot from all this. I would call Justice Nagamuthu as one of my great inspirations. I'll have to openly confess that I would call him as one of my greatest inspirations, because he was the one who really tapped my ability to lecture. I never knew that I'll be able to do it at all. So he used to sort of appoint me as an amicus curiae in many cases. I never realized why he did it, but he did it. That brought a lot of confidence in me. And thereafter, I used to look at the way in which Justice Nagamuthu and Justice P.N. Prakash used to address. That was a great inspiration for me to really tap a particular, I would say, a trait of lecturing. I never knew that I can do it, but I would call them as the mentors when it comes to lecturing, when it comes to that. So there are lots of people from whom I have really gained a lot of inspiration. So the list is very long actually. So the second question is, as between law and dharma. See, basically, dharma is supposed to be part and parcel of law, because as a judge, it is almost impossible for someone to cross the line of law and then overreach it and do something. Because what happens is, you may be doing it, but it will be struck off in no time. It will be struck off, and it is not your satisfaction. You have to comply with two things. One is, you have to comply, or you must be within the boundaries of law. And within that boundary, you must have done the maximum that is possible in a case. And you should not have done something which satisfies you, but ultimately it will go before a bench or before a higher forum, and it would have been struck off in no time. That's one thing which I actually sort of learned after becoming a judge. We learn on a daily basis. So like one recent order which I wrote, where I knew that the children were being influenced by their parents and they were doing a lots of things affecting the interest of the school, the principal. They were having a torrid time. It went to the extent of giving a POXO case and all that. So in law, what is the law saying? The law is saying that when it comes to actions taken by educational institution, disciplinary actions, courts must be very slow in interfering with it. Courts must not substitute its own decision to it. That is the law. But when I look at them, I see their age. That age is disturbing me. Age is only 13 and 15. That age is disturbing me. So something inside me, which is called, you are calling as dharma, is acting. It is acting. Now that is questioning me, when you were 13 and when you were 15, what is that you did? What are all the acts that you did? மத்தவங்களுக்கு தெரியாம போனதுனால நான் தப்பிச்சிட்டேன். யாருமே உத்தமம் கிடையாதுங்க. Every saint has a past. That's what I wrote in that order. Every saint has a past. Past இல்லாத ஒரு saintே கிடையாது. Let not even a single person here think that he is paragon of virtues. There is nobody like that. So more particularly when it comes to age, I always give that benefit of doubt. Now dharma comes into play. Now it tells me, sir, you have dismissed it. You have said that I will not interfere. Where do these students go now? Now dharma is raising up its face. It is asking me. Then what happens is something from within me tells me that give one last chance to the students where they can go and apologize before the institution. And the institution can look at them like a parent. After all, the institution has nothing personal against the students. And the students would not have reacted the way they reacted unless and otherwise they had that bad influence from their parents. So if that happens, when the court writes it, it's possible that people will sit back and think as to why we should go through this. Why don't we give an apology? And the institution will think, after all, these persons have realized it, and by just saying that in the conduct, good TC institution no problem. Institution would also be satisfied that their stand has been vindicated. Here the dharma comes into play. But what is important is that it's possible if you are overwhelmed with dharma, the problem is that your orders will be set aside. So it's important that you have your dharma within the four corners of law and keep moving. The movement must be within those four corners. That's very important.
Okay, thank you, Vishnu. Vishnu, satisfied?
I had the recent judgment of His Lordship in this issue. That's why I asked it.
Oh, typical cross-examination, knowing the answer and asking the question. Anyway, thanks, Vishnu, because your question brought out so much. So there's nobody else to that's number one. Number two, these sessions done by me have always been known for a lot of light-heartedness, but you've managed to, I must accuse you of trying to change it. Though we thought it would be a very light session, that's what we advertised it as. Your thoughts, your statements, and your seriously candid and sometimes incredible answers have made it a very intense session. I won't say it has been a very serious session. I would say it's a very intense thing. Your idea of what young lawyers should do, more importantly, what young lawyers probably should not do to be successful. And the most important thing, according to me, the takeaway of this session, a successful lawyer, what is the concept of being successful? How do you define it? You've given 3-4 probable ways of interpretation, and what you think, which is a surprise even to me, saying that if you are satisfied with what you're doing, then you're successful in your eyes. You are really not too concerned about that. Plus some unbelievable opinions and some incredibly candid answers. I just wish that, more and more youngsters see this session, because what I saw, which was the genesis for this session, was that 5-minute video. But this is almost 3 hours. In fact, Exactly 3 hours.
Yeah.
And I've just got a call from Zoom saying that they're also going to sleep. Thank you, Justice Anand Venkatesh. The script of a successful lawyer was all and more that it promised to be. Thank you very much for the time spent. We really appreciate it.
Thank you. Thank you. Thank you.
Thank you. Bye.